Hello. We are starting right now. Hi, everybody. Good to see you all. Hi, Philip Heels. I'm so happy you made it. Oh my gosh. Just going back through the chat and oh my goodness. Hi, Jody. So happy you're here, honey. Oh my gosh. Hi, CE. Good to see you. Wow. Brian Boggs. You're always there for me. Oh my goodness. And then there's a cat. Billy. Come on, Billy. Or go up there. That's fine. You can be up there. Oh my goodness. Drums. Hi, sweetie. And thank you. This is one of my favorites. Yes. Surprise cat alert. Oh my goodness, I have some fun tonight. Oh my gosh, I just realized something. Some of my fun is on the other computer. So before we start, we're just going to chill and chat for just a couple of minutes while I do some finagling around here. So everybody tell me how their night's been. Please. Oh, yeah, I did my my exclusive on my other computer. So I didn't transfer it over yet. And I got so excited about starting the stream that I completely forgot that this was needed to be done. Aww. Well, thank you. Oh, and then another kitty cat alert. That's our tech kitty. He's gonna zoom. Hi, Earl. Hi. Hello, Earl. Oh, you are not Earl. You are not Earl. You are much bigger and much, well, I can't say hairier, but you are not Earl. Doggo to the rescue. Save the stream, Doggo. Save the stream. Come on, intern Doggo. CEO Doggo. Show everybody your beautifulness. Yes. Oh, shoot. Darn CapCut. Do what I want. Close. Try again. There we go. Yay. There, y'all got early doggo time. You got kitty butt, and you got the cute meows from Earl. Eva, come on. Quit that. Okay. Okay, Eva, honey, can you please go lay down next to your heater? Go lay down next to your heater. Come on, you're heavy. Oh, well, you're here with me now, honey. I don't let nothing be blah. Oh, Bonnie. Hi, Bonnie. My practically neighbor. Good to see you. No, she is. They all are. They're so wonderful. Golly, I love them. She is out of treats until payday. Yeah. And that's not for a while. So she's just going to have to survive. All right. So now that I got my file crisis fixed, because I'm such a space case, and for some reason, y'all still love me. Okay, so now I have some awesome stuff. Oh, I wasn't worried about it. We are going to start with a couple of I don't know, child custody modification requests. So and there, I like this judge. I do. He's got a personality. But this is kind of it's like 2 hearings. It's kind of long. But it's still it's so good. And it's Texas, where everything's bigger and better.
Hey, Belinda just gave me a file. Is someone ready to go for a hearing now?
Yes.
I'm speaking to lawyers, ma'am. Sorry.
Oh, whoops.
Yeah. Everybody's ready to go for a hearing, ma'am. All litigants are always ready to go. I'm just talking about someone that has a file and the attorney's ready to go. Thank you.
Am I supposed to be speaking, sir? Because it keeps going in and out.
No, sir. No, sir. I was just asking was one of the attorney generals ready to go. That's all. Thank you.
Okay, sir.
Your Honor, are you ready for hearings?
Yes, ma'am. I know Belinda gave me a file and I announced ready. So anytime you're ready to go.
You may not have the file on this one, but Mr. Ridley is here. He's an attorney and he'd like to approach for a special setting on a case.
I never heard of some guy named Pat Ridley who's an attorney. Okay, former county attorney of Bell County. I don't know the guy.
That's the same guy, Judge.
Well, how you doing today, Mr. Ridley? Hope you had a good Thanksgiving, sir.
Oh, we did. How about you?
The prime rib was great. Okay, and the dog really thought so because she begged from everybody and everybody came through for her. So yeah.
Oh man, sounds like a good time was had by all then.
Judge, stop it. That's not fair. I can't even get prime rib, and you're giving yours to your dog. Stop this. Ava's getting mad too.
Oh.
Yeah, but she got none of the Cabernet Sauvignon, I'll tell you. All right, what's the cause on that one then, Ms. Hubbard, please?
Your Honor, it's 273473E.
Oh, a holy but a goodie. All right. And so y'all looking for a special setting?
Yes, Judge. We've been here for 2.5 hours. Mr. Salazar had asked for the child support review conference, didn't agree to it, so it got set for today, and then he doesn't show up. And we really need to get a modification on the child support, and he's got some arrears that we want to confirm.
How far out you looking at? You want to try to get it out? I'm not sure how many special settings I have before the end of the year, but let me double check and I'll see what I've got. Because we're everybody's shutting down about the 20th, so let me see what I've got. Okay.
January would be fine. That would give the Attorney General's office a little bit of time to do some research on his income. So January is fine.
Okay, then we'll go into the new year then. Let's see. All right. Okay, I'll say, yeah, I always got to bring up a separate calendar for Zoom. That's just the pain it is. It says it'll sync to Google, but it doesn't. So
I'll be honest, I thought I cut all of this out after the Thanksgiving dinner talk.
Yeah, we're in January now.
So I apologize that I missed cutting out the scheduling.
I've got all morning available. I got the 9:30, 10:30, and 11:30 slots available on Wednesday, January the 10th. If you want to, you don't anticipate it'll take more than an hour, do you, sir?
No.
Okay, so I've got 9:30, 10:30, and 11:30 slots available on the 10th of January. Would one of those work for you?
Well, I'm just concerned that, the Attorney General's office was indicating they needed a little time to put together information about his income. So that might be.
That's more than 30 days out. You think y'all can do that, Ms. Hubbard?
Your Honor, we're going to try to. He's showing as having a new employer.
Okay,
we're not-
all right. Let me go to the end of January. Okay, no problems. Let's see. Okay, the day before my bro's birthday, 24th, I've got only got one hearing so far that date. That's the 9:30, so 10:30, 11:30, 1:30, 2:30, 3:30, all available. So morning, afternoon, we'll work on that date, Mr. Ridley. Any preferences, sir? Will that date work for you and your office?
That'd be good if we could do a 1:30.
All right, then. All right, then I'll go ahead and set the special setting for 1:30. I'll do that right now and get the Zoom code out to the AG's office, and they'll forward it to you in the reset order, sir. Anything else?
That's all, Judge. Thank you very much. Have a good Christmas.
Merry Christmas to you too, sir. You take care now.
Thank you.
All right, let me go ahead and make that Zoom code, Ms. Hubbard, and I'll be right back.
Thank you, Your Honor. Thank you, Mr. Ridley.
Thank you.
We'll see you in January.
Yes.
Your Honor, when you're available, I have a hearing ready.
All right, what's the cause, please?
This one is Bell County cause number 311467.
Okay. What was that number again, please?
311467.
Okay. All right, the court's going to go ahead and call Bell County cause number 311,467-C. This is in the interest of Cano minor child, non-custodial party being James C. Pollard, custodial party being Krista Naomi Cano, and this matter is before the court on a suit for modification of child support and motion firm arrears. Court's taking judicial notice of the court file. Note for the record that Mr. Pollard was served in August of this year. Ms. Cano in July, so both parties are properly before the court and under requirements of the Texas Rules of Civil Procedure. So at this time, I have to state for an open to tell the court what the state's requesting we do here today. Let the state let this court know are both parties present, or is this a default, and what's in agreement and what's not, and finally, if this is going to be a final or temporary order. Thank you.
Thank you, Your Honor. It's the state's understanding, both parents are present, Ms. Cano pro se and Mr. Pollard represented by Mr. Tanaka. It's the state's understanding that we have an agreement on the state's pleading the suit for confirmation of arrears and modification of support order. Specifically that the new support obligation from Mr. Pollard, $838 per month, begins September 1, 2023, which was after both parents were served. The state is seeking to find is seeking a future pay finding, that Mr. Pollard was paid ahead 20 cents as of August 31, 2023, and carry that amount forward. The state is also...
I've never had that one asked before if it's under $1, but go right ahead, no problems.
Thank you, Your Honor. The state is asking that this court approve the parties' agreement that Mr. Pollard maintain the CHAMP VA for the child. This was in effect roughly in May, but the medical support ordered previously continued through that August 31 date, and no support amount for medical going forward. The child will actually be double covered through the Mother for Government as well. The issues for the court to decide, Your Honor, are based on the parties agreeing to waive defects in service and pleadings to address communication by app close. It wasn't pled for by the state or Mr. Tanaka's cross petition. The pickup and drop off location for the child Sophia testimony will show that father is in Illinois and is seeking for either parties to meet in Tyler, Texas, or to have each parent be responsible for a leg of Sophia's journey. And then parties are in agreement to have electronic communication for parent not in possession on Thursdays from 7 o'clock to 7:30 p.m. Central Time, and on Sundays between 9:30 a.m. and 10 o'clock a.m. Central Time. And finally, Your Honor, parents are in agreement to have the court address the issue for determination of disclosure of addresses. Mr. Pollard is seeking all of the information from Ms. Cano, who is hesitant to provide such and will give testimony as to why, Your Honor.
Okay, just a second. I'm reviewing the old file here real quick. Well, we said it's old order, sorry. File to file. All right, real quick, does Ms. Cano still live in Bell County?
No, Your Honor.
All right, well, let's get, okay. Well, let's get some testimony on that. All right, thank you. So at this time, I'm gonna go ahead and swear the parties in. Mr. Tanaka, is your client with you, or is he on a separate Hollywood Square in here?
He's on a separate one, Your Honor. His video should be there. James
I got
Pollard.
it. See him now. Thank you. All right, then
Yes,
I'll
sir.
ask both Ms. Cano and Mr. Pollard both to raise your right hands, please. Do you both solemnly swear or affirm your testimony you're gonna give here today is the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
Mr. Pollard, do you so swear, sir?
I do, Your Honor.
All right, you're both officially under oath, and I'll go ahead and allow the you can put your hands down. Allow the state to call their witnesses at this time, which are obviously look like only you two. And then I'll go ahead and allow cross-examination by Mr. Tanaka. And then at the end of the hearing, Ms. Cano, if you wish to make a closing statement because you technically represent yourself, you'll be allowed to do so, ma'am. Anyway, I'm going to let the state call their first witness, please. Thank you.
Thank you, Your Honor. The state calls Ms. Cano. Ma'am, what is your full name?
Krista Naomi Cano.
Who is the child in this case?
Sophia Rose Cano.
How are you related to Sophia?
I'm her mother.
Who is Sophia's father?
James Christopher Pollard.
And Ms. Cano, is it correct that Mr. Pollard was the person previously ordered to pay both child support and medical support in this case?
Yes, that's correct.
And were you able to hear my opening statement to the court, ma'am?
Yes, I was.
And was it accurate as far as the agreements between you and Mr. Pollard for current support beginning September 1 and and Mr. Pollard being responsible for Sophia's CHAMP VA coverage?
Yes, that was right.
So you were fine with the $838 child support beginning September 1 and a finding that Mr. Pollard was paid ahead slightly as of August 31st, 2023?
Yes, I am.
And as far as the additional issues, Ms. Cano, you were made aware of the cross petition filed by Mr. Tanaka on behalf of Mr. Pollard?
Yes.
And as far as the agreements reached, you are comfortable with Mr. Pollard having electronic communication with Sophia on Thursdays from 7 o'clock to 7:30 p.m. Central Time?
Yes, on Thursdays. Yes.
Yes, ma'am. And on Sundays between 9:30 a.m. and 10 o'clock a.m. Central Time as well?
Yes.
And you understand, ma'am, that if you were not, if Sophia was with Mr. Pollard on these specific days, you would also be entitled to those days and times for communication electronically?
Okay, thank you. I am now.
Yes, ma'am. Additionally, you were not in agreement to communicate using the parenting application AppClose?
No, not at this time.
Any particular reason, ma'am?
Because I think that we've been doing okay with communicating through the Messenger, Facebook.
And is it correct, ma'am, that you were also asking this court to consider, oops, I don't see her.
Okay. I thought she was in a vehicle. I hope she wasn't moving. That does that sometimes. There she
I'm
is.
not driving. I'm parked at
Okay,
work.
I know, yeah, okay. Again, you might be a passenger. I've had that happen too. So, but yes, ma'am, you're back on. No problem. You may proceed.
Thank you, Your Honor. Ms. Cano, my last question was, is it correct that you're asking this court to decide whether you need to disclose your physical address and other contact information to Mr. Pollard?
Yes, I am.
And ma'am, why is it that you are not wanting to do so?
Well, I would just rather avoid any potential drama or arguments going forward. I know that while I was dating someone previously, he had messaged them without my knowledge and threatened them.
I'm sorry, ma'am, I couldn't understand you. Can you please repeat that, please?
Yes. I just want to
Go ahead and turn
avoid
off-
any
Ma'am,
conflict.
ma'am, excuse me. Go ahead and turn off your video. Maybe we'll get a little bit better connection because you're flipping in and out real bad on your art video. So let's turn that off and hopefully that'll up the audio. Yeah, now go ahead and explain, please, ma'am. Thank you.
Yes, Your Honor. I just want to avoid any conflict at all possible. I know that when I was dating someone previously, he had threatened them through message because he felt the need to protect Sophia for some reason. He said that if he hurt her, that he would be dead. I just want to avoid all drama and all of that, if at all possible. I don't want him to randomly show up.
To be fair, that sounds like a dad thing to say. It doesn't sound like an actual threat. It just sounds like something that a father of a very young child would say. And as far as I don't want him to randomly show up, he lives in Illinois. Y'all, she lives in Texas. I don't think that he's going to drive 16 hours to randomly show up just to cause drama with her.
Have to deal
Okay,
with.
ma'am. Okay, ma'am. I'm trying to figure out why everyone using a communication app would make that problematic. Because I really don't
Oh,
like
it's not
Facebook.
for the.
I'm sorry, ma'am. Go ahead.
Yes, Your Honor. It's not for the app. It's for him knowing my address, physical address.
Okay, man. Well, we're talking about I thought the question was about the app. I may have missed something there real quick, but we're talking about using the
You did.
parenting app for all communication. The FaceTime, the everything is done through AppClose, and AppClose actually has a function whereby later on, if we need that information, what was said one way or the other through the app, a lawyer can get it. Your lawyer, his lawyer, whatever. So I always use AppClose, ma'am, and that's pretty much that.
That I can understand. I can agree to use that. It's
Okay.
probably better for proof.
Yes, ma'am, it is. Okay. But anyway, okay, I'll let the state, I'm sorry, Ms. Bungata, maybe our judge had a momentary lapse of reason there. Okay. Old album, you guys are way too young for that. Anyway, but bottom line is, I'll let you go ahead and ask the question again. She was on the thing about about an address information, so I'll let you go ahead and proceed. Thank you.
Thank you, Your Honor. Ma'am, how long ago did that threat occur?
That was actually April 23rd of 2021.
And since then, ma'am, is there anything else that would give you concern about providing your contact information to Mr. Pollard?
Threatening wise, no, ma'am.
And ma'am, your current method of communication with Mr. Pollard is Facebook Messenger. Was that what you'd said?
Yes, that's correct.
And ma'am, do you have any problem with changing the method to AppClose, which would be a place for everything related to your daughter, including video messaging or cash transfers if there were any unreimbursed medical, that kind of thing?
I can change to the AppClose. I'm comfortable with that.
Okay. Moving to the issue of pickup and drop off for visitation, ma'am. When the original order was done, were you a Bell County resident?
Yes, I was.
At this time, ma'am, what county do you live in?
I am in Travis County now.
And ma'am, had you moved to Travis prior to Mr. Pollard moving to his current state of residence?
Yes, I believe so. I've moved a lot. I don't know when he moved to Illinois.
And ma'am, since you moved, who was responsible for the pickup and drop off of Sophia?
He was responsible, but I would meet him.
Was there a specific place or specific place that you and he were meeting?
So in Leander, when I was living in Leander, we would meet at the HEB there. And then when I was living in Hutto, I lived there for 2 years, we would meet at a gas station called Hutto Mart.
And since he moved to Illinois, ma'am, what has the pickup and drop off looked like?
Well, he hasn't seen her. He's seen her once this year for the summer. I let him take her for 42 days. Let me double check.
Sorry, ma'am. So where did that exchange take place?
The agreement to pick. We met at Sophia School, my work school in Austin, because he was living in South Austin as well.
Okay. So do you know how recently he moved to Illinois?
I do not.
Okay. Was there anything in particular, ma'am, you were wanting the court to order for these requests, the request for exchange place and, well, that's the main request, ma'am.
Just not something that's gonna burn out my car because it's already like damaged, a clunker. So I only use it for work in the grocery store. I'm comfortable with driving maybe an hour, but I think anything more will damage it even further.
Thank you, ma'am. I pass the witness, Your Honor.
All right, ma'am, back here. I'm sorry. Your witness then, Mr. Tanaka, thank you.
Great, thank you, Your Honor. So Miss Cano, let's see. Are you currently dating that boyfriend that you mentioned?
No, I am not.
Okay. Are you currently dating anyone?
No, I am not.
Okay. Where do you currently work?
I still work at Leaps and Bounds. I've worked there for almost 6 years.
At where? I'm sorry, could you repeat that one more time?
Leaps, the letter N for November, Bounds.
Okay, great. And is that daycare or school?
It's a preschool.
Okay, great. Is this the same one that the child goes to?
Yes.
Okay, great. What is your work schedule there? Are you full-time?
Yes, I'm full-time.
Okay. How far away is that from your house?
Without traffic, it's about 15 minutes, but I
Okay.
have to be here at 8 most days.
Okay. So it sounds like we're going to reserve the contact information parts for the judge. So I won't ask you what your phone number, address, or your email is at this time. You did mention that your daughter attends preschool at the Leaps and Bounds facility.
Yes, she graduates in May.
Perfect. Okay, that's awesome. And is my client listed as an emergency contact there?
No, he's listed for pickup.
Okay. Is he able to be listed as an emergency contact there?
He is, but I don't see the point if he's in Illinois, because he can't do anything in
Okay.
an emergency.
Here's the deal, ma'am. He's the dad. He's going to be, ma'am. I'm sorry. That's just the way it works. It would work the same way with you. Proceed. You don't have to go. You have to go on that any further, Mr. Tanaka, ma'am. Unless there's a legal reason he shouldn't be named, and you'll be up to you to give me a legal reason. The fact he lives in Illinois is not a legal reason. Distance is not one. So, but I'll let you explain that to the court why you think it's inappropriate as far as the law is concerned. You may proceed, Mr. Tanaka. Thank you.
Thank you, Your Honor. So Ms. Cano, I want to kind of dive in a little bit deeper and kind of follow up with what Ms. Bongot asked you about this threat. And that really is the crux of the reason why you're not providing my client with your mailing address, phone number, and email, and have really forced him to communicate via Facebook Messenger only past couple of years. So I want to talk about this threat because it seems very important to you. So I want to make sure I understand it better. Did my client, Mr. Pollard, ever threaten you directly?
No.
Okay. And Ms. Bongot asked this again, but I believe you said this threat happened 2021. Is that correct?
Yes, that's correct.
Okay. And if I heard you correctly, the threat, what he told your boyfriend was something similar to the lines of, if you hurt my child, you're going to be dead, essentially. Is that correct?
Yes.
Okay. Okay. And in what form did he communicate with the boyfriend? Was it through Facebook, phone call, email?
It was through Facebook Messenger.
Okay. Did the boyfriend reach out to the police and, try to get them involved or anything?
He considered it, but he dropped it, so no.
Okay. And explain to me how that statement threatens either you or the child?
Well, I know that I just don't know what he was capable of.
Has he ever been violent towards you at any point during your relationship or even after it?
No, we only dated a few months.
Okay. To your knowledge, has he ever been physically violent with any other person, any of your friends, family, that kind of thing?
No, not to my
Okay.
knowledge.
Okay. And he's never been violent towards the child?
Around me, no, but I don't know what he does.
So a few months was not time enough for her to know whether or not he was violent, and it wasn't time enough for him to know whether or not she was a Karen. Got it.
He's with her.
Okay. Okay. What kind of car do you have, Miss Cano?
I have a Nissan Versa.
Okay. And you mentioned that you're worried about driving it. Is it in the shop, or is it going to be in the shop here pretty soon?
Yes, it needs to be. I'm actually going to try and junk it once I pay it off in hopefully February and
Okay.
get a new one, or a better one.
How far away is Tyler, Texas from where you're currently living?
Let me double check. I don't want to get the wrong. It's 3 hours and 48 minutes.
Okay. And you only have one car in your possession?
Yes, just one.
Okay. No further questions at this time, Your Honor.
Your Honor, I think you're on mute.
Ma'am, what year is your vehicle?
It is a 2019, but I got it from a second chance dealership, so it was already used.
And how many miles does it have on it?
Over 100. It's not showing right now.
Over 100,000?
I'm sorry.
Over 100,000?
Yes, Your Honor.
All right, thank you. All right, anything on redirect, Ms. Mungat?
No, Your Honor.
All right, ma'am, be back in a moment. You can call your next witness, Ms. Mungat.
Thank you, Your Honor. The state calls Mr. Pollard. Sir, what is your full name?
James Christopher Pollard.
How are you related to Sophia?
I'm her dad.
And sir, is it correct that you were the person ordered to pay both child and medical support in this case?
Yes.
Were you able to hear my opening statement to the court, sir?
Yes, I was.
And were you in agreement with your new support amount of $838 beginning September 1st of 2023?
Absolutely.
And any problem, sir, with the court finding that you were paid ahead 20 cents as of August 31, 2023?
I actually didn't understand that part, to be honest with you.
Yes, sir. What the state is asking is for the court to find that specific number so it can apply to the future obligations, and any monies paid toward the cash medical support go where they need to go based on the new orders.
Oh, okay. I'm comfortable with that.
And then, sir, is it correct that you have your daughter covered through health insurance?
Yes, it's called Champ VA.
And is there any cost to you, sir, to provide that for her?
No, it's a free benefit that I get as a 100% disabled veteran.
And sir, you understand that the child support was calculated according to guidelines, so 20% of your non-taxable income?
Yes.
And sir, were you able to hear the mother's testimony?
Yes, I was.
And so at this point, sir, it sounds like you and she are in agreement to communicate going forward using app close and having those specific electronic communication times with Sophia on Thursdays and Sundays.
Very happy with that.
And sir, when exactly did you move from the Central Texas area?
I can look back. It would take me a long time. I let Kristen know that I was coming up here for a little while. So I wouldn't be able to pick up Sophia. And, so I moved up here February of last year. And it wasn't really set in stone whether or not we were going to stay here until later on in the year that we realized we're going to build our house here.
And sir, would you agree that the last time you saw your daughter was this past summer?
In person, yes.
Okay. And sir, have you provided all of the contact information you're requesting from Ms. Cano to her with regard to yourself?
Yeah, I've given her my updated phone number. She hasn't asked for anything else, but I'd be happy to do that right now.
Okay. And then, sir, with regard to the exchanges of Sophia, what are you wanting this court to order?
I totally understand having vehicle problems. One of the biggest reasons that I need it to be kind of a separate thing is because I drive a very old vehicle covered in rust. um, I think it's more than fair for me to drive from Maroa, Illinois to Tyler and only have Krista go up to Tyler if she's capable. Which it looks like, I mean, if she gets her car fixed or gets a new vehicle, maybe that can be a thing.
Thank you, sir. I pass this witness, Your Honor.
All right, Mr. Tanaka, you're a
Ooh,
witness.
good point, sir.
Thank you, Your Honor. Mr. Pollard, just a couple of quick questions for you. Could you explain to the court why you moved to Illinois briefly?
My wife's family, they're getting older and they needed help. Help around the house, just doing grocery shopping, things like that. Recently, my wife's uncle that was caring for his mother, he just passed away. So a lot of the responsibility is on me and my wife to kind of help out the rest of the family.
Okay. I want to talk about just your ability to communicate with your daughter recently. During the week, would you say that on a regular basis that you're easily able to stay in contact with your daughter?
No.
Could you explain?
I'll ask questions. For instance, this last weekend on Friday night, I asked Krista if I could talk to Sophia this weekend, and I gave her a approximate time frame that I would be available, and see if we could go, break it in. And instead of we'll make this work so that Sophia can see her dad, she said no, she'll be busy. The rebuttal was, why don't you talk to her now? And that puts a lot of pressure on me because I don't know, is Sophia getting her hopes up, hearing that, hey, dad may call, but I can't, and then I'm making her feel bad. It really is disappointing. So I waited Saturday. I didn't get a call, and I waited Sunday, didn't get a call. What I did receive was 2 pictures of my daughter at a park, and a start of an argument from Krista when all I'm asking is 10 minutes of my daughter's time so she knows I'm thinking about her.
Okay, so you would agree that hopefully having set days and times in place for electronic communication is going to help big time, correct?
I hope so. This gives something that Sophia knows for a fact she can look forward to. Krista should be able to make time. I should be able to make time, unless extenuating circumstances, which are understandable as well.
Sure. And I guess, would it be helpful for the judge to order that, I guess, the parent not in possession of the child be the one who initiates the call?
I'm sorry. Can you ask again what you just said?
Sure. Would it be helpful for the judge to order that the parent not in possession of the child be the one responsible for initiating the call, just so there's no confusion as to who calls who at the appropriate time?
Absolutely.
Okay. Great. Has Miss Cano ever given you a phone number to reach your daughter at?
Yeah, apparently it's the wrong one. I believe that's the number that I shared with you, and we found out together that it didn't work.
Okay. Has she ever blocked your phone number to your knowledge?
She's blocked me on Messenger multiple times whenever we had disagreements.
And that is the only way that she's given you to communicate with her previously, is that correct?
Right. I've wanted to do health and welfare checks in the past, especially once I found out about that arrest. But I don't have an address or a phone number. I just have a name, and I didn't know if I could even do anything with that.
Has she ever given you a mailing address so you can mail your daughter birthday cards or packages on her birthday?
No, she refuses to give me an address.
Have you requested that from her?
Multiple times.
Okay. And what is her response when you request that?
I'm not comfortable with that.
Okay. So I'd like to kind of touch on that because as you heard Ms. Cano talk about, really the comfortableness, the I'm not comfortable stems from this 2021 instance, do you happen to recall that Facebook Messenger message that you sent to her boyfriend at the time?
I do indeed. Yeah.
And is it accurate that you said something along the lines that if you hurt my daughter, you're good as dead, pretty much? Was that correct?
Yes.
Okay. And I mean, do you generally agree with that statement?
My statement revolves around the fact that I want the best for my daughter. I want to know she's safe. And because I don't have any information, I'm pretty on high alert.
Right.
It's really hard to not know where your daughter is ever.
Did you make that statement to threaten his well-being, or was it made out of concern for your daughter's safety and well-being?
I'm a former infantryman. I'm used to just talking tough to somebody to get a point across. But the point that I was trying to make is my daughter's important to me. She's the most important thing in my life. And I don't know who you are. So just know that I hold her the most.
Y'all, I love this dad, and I'm sorry, but his statement of I'm used to talking tough to somebody, I don't see it. He looks like the most wonderful nerd that you're gonna meet. I don't see an ounce of tough in him. But I get he was in the military. He's Army. I'm sure it's in there. But he looks so dorky, and I love it. And I really can't stand the mother. Y'all, any woman should be grateful to have a man wanting to be a part of their child's life. You know, who's not griping about the amount of child support they're paying, who pays it dutifully and faithfully, and and agrees with it, plus provides medical coverage. And it's just gross that the mom doesn't appreciate that, and that she's making it difficult for him to be a part of his daughter's life. Like, that's not fair. Pog. Okay, I got it wrong. What is a pog? I know he said he was infantryman. But you're going to have to clarify that for me, please. Later on, the judge mentions that she's a jarhead. So she's I think, Marine. And yes, thank you, drums. Yes. Yeah. Oh, permanently on ground. Okay. Yep. 100%. All right, guys. I just wanted to break in for that, but I'm going to go back to it. I love you all.
Totally understand. Okay. And Miss Canoa said this, but you have never physically assaulted, hurt Miss Cano or your daughter, have you?
No, I've never had any case of assault of any sort.
Okay, great. And are you asking the judge today to order that Miss Cano be ordered to provide you with a current email address, phone number, and mailing address so you are able to stay in contact with her and your daughter?
Absolutely. What if something happens and I need to get there? I mean, if there was an emergency, God forbid, I have no idea where to start.
Understood. Okay. And you're comfortable with giving her the same information on your end?
100%.
Great. And you are asking the court to order these periods of electronic communication, the Thursday from 7 to 7:30 and the Sunday morning, 9:30 to 10, Central Time every week?
Yes.
And are you requesting that the child's mother and this would apply to you too, but whoever's with the child not be present during those calls unless there is a valid reason for the child's safety or well-being?
Yes, and to mitigate the concern, I believe Krista shared with me about Sophia playing with the phone or something. Have the phone in a stand. Make it a rule. You can't touch the phone while we're talking. Obviously, whenever I have Sophia with me, I'll do the same exact thing. I have a phone stand, and we can do it that way. But as it is right now, Sophia always looks up to her mom to know what to say to me when I ask her questions.
Okay. Let's talk about travel, pickup, drop off halfway. So how far of a drive is it for you to drive from where you're at to Tyler, Texas, where your parents live?
I actually did the math all the way to Austin.
Okay.
That's about 15 hours away. So a little bit over 960 miles. I drive a pickup truck, so gas mileage is not the greatest, but I make it work. I've actually borrowed family members' vehicles from up here to get down there. My parents' house is obviously about, I think, 4 hours less in time.
Okay. Would you be comfortable with a judge ordering that you exchange the child at your parents' place? So that would be, I think Miss Cano said, roughly a 4-hour drive for her. For you, it'd be roughly 11 hours. Would you be fine with that?
I'm absolutely fine with that. If Krista needs help in that kind of scenario, that's fine. Most important thing is I can get Sophia.
Right. And I guess if she's not able to pick up the child, well, I guess we'll take that step as we get down there. But you're fine with pickup drop off at your parents' house in Tyler, is that correct?
Yes, sir.
Has Sophia ever flown before? Is flying an option? Do you know?
Well, to be honest with
Probably
you, I've been in a couple plane incidences where I have fear of flying myself.
Okay, no problem.
Yeah, I've been shot down and had a couple catch fires. So I wish I was not afraid of flying, because that would be a wonderful idea.
Has Sophia flown ever by herself, or do you think both of you would be comfortable with that?
I don't think she's old enough to fly by herself.
She's way too young, Mr.
Yeah.
Yeah, don't do it yet. I wouldn't do
Yeah, absolutely not. If she was escorted by her mom, or I hate to say it, but I would still escort her on a plane.
Yes, sir. Okay, well, great. I just wanted to touch base with that, but it sounds like driving should be sufficient. So
yeah,
that's all the questions I have for you. I'll pass the witness, Your Honor.
All right, anything on redirect, Ms. Mongat?
No, Your Honor.
All right, then. I don't have anything specifically at this point to ask Mr. Pollard. Do have a couple of things to ask Ms. Connell. You still there, ma'am? You kind of everybody moves around.
Yes,
yeah. Okay. You're now looking like you're on a landline. Did you recall in on a different device, ma'am?
No. I think it just took me off.
But don't worry about turning on the video. We're good. We're good. Anyway. All right, ma'am. I'm sorry. Any other witnesses at this time, Ms. Mongat?
None, Your Honor.
All right, Mr. Tanaka. Any other witnesses you're going to call, sir?
No, Your Honor.
All right, Ms. Connell, I got a
Your Honor.
couple things I want to give you the opportunity to explain to the court, or anything else, and then make you make a closing statement. Here's the deal, ma'am. I was looking at your old order. So long as you lived in Bell County, it was dad's responsibility to pick the child up and drop the child off at your residence. But once you moved, and this is straight out of Texas Family Code, it's his job to pick the child up at your residence, technically at the beginning of visitation. But now at the end of visitation, it is your responsibility to retrieve the child from him. So obviously, him making a drop off and pick up at Tyler is definitely to your benefit. But again, ma'am, I'm looking straight out of your old order. If you check it yourself, you'll see that's what it says. So again, now that you no longer in Bell and he's no longer in Bell, I'm looking at the responsibility falls on you equally to pick up and drop off the child at the beginning and at the end of the visitation. The other thing I've noticed, there was no restrictions placed on the exchange of address information, telephone information at the time of the last order. There was no finding of family violence, so there was nothing along those lines. And under the court order, ma'am, you were ordered to keep him informed of all your addresses, all your phone numbers. I don't think email was included in that, but addresses and phone numbers are there. And technically, ma'am, when you refused to do that because you said you didn't feel comfortable, it was no longer your decision. It was my court order. And technically, ma'am, no one, Mr. Tanaka did not file an enforcement against you. So I'm not looking at holding you in contempt for violation of the court order, but that could have been done, ma'am. So, and because I've had people held in contempt for not keeping up with addresses, phone numbers, and so forth and so on. So you need to be aware of that. That's something that's out there, and that's something that was in the prior order. And there appears to be no request to change any of that information. So, ma'am, at this time, I'm definitely it's technically his responsibility to pick up at the beginning of visitation, yours at the end, so forth and so on. So at this time, ma'am, is there something else you're asking the court to do? Is there some other information you think I need to know that didn't come out in either your testimony earlier and you think I need to know at this point, ma'am? So I'm going to let you go ahead and do a short narrative on those points, ma'am. Thank you.
Yes, Your Honor. So I actually have photograph proof that he did have my Colleen address, because he asked me if my address was still on French Street.
Okay, well, ma'am, you haven't lived in Colleen in 2 years, ma'am. So that doesn't matter. That's that point is moot, ma'am. Correct. You just testified you haven't lived in Bell County for over 2 years, correct?
Correct.
Okay, go ahead, ma'am. Sorry.
Nice try, lady.
And he also had my Hutto address. He received that August 3rd of 2020, and I lived there for 2 years. Okay. He knows where Sophia goes to school. I've also given him the address for that, August 5th, 2022.
Okay,
so
well,
he's been picking her up there.
All right. Well, here's the deal, ma'am. Going forward, no matter it's the responsibility of whoever moves within a 30-day time frame, or within 30 days of moving, or as soon as they know they're moving to a new address, to let the other party know what that address is and let them know what the phone number is. So going forward, ma'am, it's up on you if you move to tell him where you moved to and give him your new phone number to a new phone number, and vice versa. Same with him. Understood?
Yes, Your Honor.
Okay. All right. Now, I'm going to I think we're in agreement. Everybody's going to use AprilSeering going forward to communicate. So that means even the FaceTime visits that each of you would have when the child's with you, you can use AprilSeering to do that. So we don't have to use Messenger anymore. We can verify times and dates through AprilSeering. And do you have a problem with? And you said you didn't have a problem with that. Is that correct, Ms. Cano?
That's correct.
Okay. All right then, ma'am. And also going forward, I think it's in there, but if it's not, I'm specifically ordering you to put the father in, no matter where your child's in school or daycare going forward, that dad's information is included as a contact person and as the father of the child. Understood?
Yes, Your Honor.
Okay. All right then. Okay, ma'am. I'm letting you. Something else you're asking the court to do, or do you need an explanation of something, ma'am?
Yes. Both. So I also felt the need to say I was in the Marine Corps, but I never threatened his girlfriends, which I knew of. I guess this is the third one.
I'm sorry, ma'am. You kind of cracked up on what was that last statement, please?
I've never felt the need to threaten any of his girlfriends. I didn't know them. I didn't say anything to them. I also, one of the reasons that I have so little time to devote to him is because I work 6 days a week. I have a second job on Saturdays, and he thinks that he knows my work schedule, but I work until 10 Saturdays. And he's like, well, I assume you have a babysitter. I assume you have this and that.
Okay, man. What's your point now, ma'am? I'm sorry. Well, what's your point on for this line?
How am I? It's a little bit more difficult for me because how am I going to drive 11 hours on a Sunday?
Here's the deal.
That's my only day off.
All right, here's the deal, ma'am. This is not me. This is the legislature of the state of Texas who came with these rules. Again, like I said in my opening statement or a speech this morning, I'm locked in. The legislature says, so long as you live where you live, it's it's his responsibility. And now that y'all both live in separate locations, it becomes half your responsibility, ma'am. I can't change that. That's what the law. But he's willing to go ahead, and I can make it part of the court order that y'all will make the exchange in Tyler, Texas, But otherwise, ma'am, he's got to pick up down where you live, and then you got to pick up where he lives at the end of visitation. And I'm telling you, based on the testimony and everything I've heard here today, I think that Tyler, Texas is definitely a better route for you to go with, ma'am. And it's up to you to follow up on the order. You know, you're both adults. You're both, I understand you got a big time work schedule, but the bottom line is the legislature says this is your responsibility going forward, ma'am, and this responsibility is enforceable.
Yes, Your Honor. I also have dates of when I've sent photos or videos and have called, allowed her to video call him.
Technically, they both moved. He moved first, and she was still in Bell County. And then she moved outside of Bell County, which then makes the fact that he moved a moot point, because now they're both outside of county and she has to follow just the standard rules of pick up and drop off means that each party's responsible for one way. So he wants her to meet him at his parents' house in Texas, which is about 3 hours from where she lives. He's willing to drive over 11 hours to get to his parents' house, and she's not willing to drive 3 hours to get there because she might have car trouble. Ridiculous. Ridiculous.
So I never restricted her from seeing him. And as far as being around when she's talking to him, I don't have a phone.
She's 4 years old, right?
Yes,
3.
that's correct.
Oh yeah, you got to be around. Okay, I'm sorry. This is she was 15. Then no, but no, that wouldn't be a problem. But she's 4. You're going until a certain age. Yeah, you got to be there, and vice versa. When he's there, yes, he's got to be there with the device or the that he uses to let her communicate with you. That's not a problem, ma'am.
Yes, Your Honor.
Okay. All right. Anything else, Ms. Cano?
That's all I can think of right now.
I'm sorry, ma'am.
That's all I can think of right now at this time.
All right, ma'am. Again, I'm looking at. Again, I know vehicles. Everybody can't afford to go out and buy a new vehicle every year, or like my cousin Mickey. But the bottom line is, that transportation responsibility falls on you now, and that's based on what the legislature says I've got to order. So are you okay with me setting the exchange at his parents' house at or location residence in Tyler, Texas? Because obviously, ma'am, that works for you best. Now, later on, if y'all both want the other long distance that lawyers use, the Texas use, is a whereby everybody's ordered he's ordered to fly down and pick the child up from you, and you're ordered to fly down up and pick the child up from him. But for right now, obviously y'all can agree to do that in addition. But are you okay with me going ahead and ordering that instead of pick up and drop off at the individual residence of the parties, that we make the exchange in Tyler, Texas?
Yes, the Tyler would be better.
Oh yeah, it's definitely he's doing 2/3 and you're doing 1/3, ma'am. So yeah, that definitely would work better.
In other words, take the deal, dummy.
In my opinion. So, all right. So I've got no problem making that the order also. All right, folks. I'm gonna go ahead and I'll go ahead and ask this point, and I'll start with the state. Is there anything else? And I'll go ahead and make some more rulings here as necessary on everything else. But is there anything else the state wants to bring out at this point as far as the information and requests of the parties at this time, Ms. Mongat?
No additional information, Your Honor, but one thing the state hadn't mentioned in the opening statement was its belief that the court would be waiving costs due to parents' prior military service.
Oh yeah, she's a jarhead, and you were Army, sir?
Yes, Your Honor.
Okay, well, no, yeah, but those two don't mix. I'm sorry.
we learned the hard way.
Oh yeah. The oldest boy is a jarhead, and my dad was 82nd Airborne. So yeah, and he didn't like airplanes that much either. But it is what it is. All right. So,
all the way, Your Honor.
Okay. All right then. So, yeah. Okay. So yeah, of course I'm waiving court costs. No problem with that. So anything else, Ms. Okay. Anything else, Ms. Mongat? Because again, I'm getting ready to let everybody make a closing statement, but I just want to make sure I don't have to hear any more testimony from my other party on anything.
No, Your Honor.
All right. Any other testimony that you want to elicit at this time, Mr. Tanaka, from my other party?
Could we either call mom so she could provide her address and phone number, or could she just privately give that to Miss Bongat so that can go in the final order?
I'll let y'all go back in the breakout room and get that information, okay? But not here online, obviously. Thank you.
Right, I don't want to. Right, exactly. Yes, you're
all right. I want to get that done today and set up. So, any other questions, though, Mr. Other party, Mr. Tanaka?
No, Your Honor, that was it. Thank you.
All right. Well, obviously, like I said, I'm going to go ahead and keep the agreements as far as the parties concerned, dealing with child support, so forth and so on. I'm going to go ahead at this time and order, and if everybody's in agreement with everyone using app close going forward, let's go ahead and download the app to your devices and register, and that's a done deal. I'm going to go ahead and order based on the fact that neither party still lives in Bell County, Texas, that we're using the standard as per the access to possession that's in the Texas Family Code, as in their prior court order. However, at this time, the father's in agreement that, and the mom's in agreement that instead of each of them driving all from Illinois to Texas and Texas to Illinois, that the exchange will take place at his parents' home and residence in Tyler, Texas. And if mom doesn't have that address, obviously, dad will make sure she gets it. Everybody needs to I'll also usually throw it out that at least 24 hours, I'm sorry, that at least 72, with these distances, I'm sorry, at least a week ahead of time, sir, you need to let mom know that, yeah, I'm coming down for the visit, for the exchange, to make sure she knows. And when everyone leave, I mean, when you leave, sir, you need to let her know also, okay?
Yes, sir.
And all that will be through app close. I'm going to go ahead and I've already ordered that mom is going to list you on the child's daycare and schools as being dad, and keep you up with the information on whether any daycare or any school the child's attend, because obviously you have the right to talk to those providers either via phone or in person if you want to, sir. So that's, and again, that's always, that's the norm of the court order, and everything else that was in the prior order is in still full force and effect. So is there anything in closing that anybody needs me to specifically rule on that I missed here? And I'll start with you, Ms. Bongat. Anything else you need to prepare that order that I missed?
No, Your Honor. Thank you.
Mr. Tanaka, anything else?
You didn't orally say it, but I know it came up before, just that mom has to provide Miss Bongat with her phone number and current mailing address.
Right, and we're going to do that in the breakout room, right? So,
yes, Your Honor. Okay.
All right, and all parties can be in there because, again, Dad, under the prior court order, that was part of it, and that wasn't asked. No one planned to change that. So I'll put y'all all in. I'll ask Ms. Bongat to put y'all all in the same breakout room where that information will be exchanged. Now, Ms. Cano, is there anything else, ma'am, you're specifically asking me to rule on today, or anything you need an explanation of, ma'am?
I'm sorry, Your Honor. I did not hear you.
I'm sorry. Is there anything else, ma'am, you need the court to explain at this time, or is there anything else specifically you're asking me to make a ruling on, ma'am?
No, Your Honor.
All right, then. I'm going to go ahead and let y'all go in the breakout room. Again, folks, allow this. I know you're not lawyers, and Mr. Pollard has one, ma'am. I know you're not one. You have a copy of your old order from this court?
Yes, Your Honor.
All right. Read the access and possession parts of that, ma'am, especially that last page that explains the rights under the order and everything. So again, everybody's nowadays. 20 years ago, there was no such term as co-parenting. But again, I think that's the new in phraseology. So y'all need to kind of work together on this, and especially since the distances y'all live apart, y'all need to actually correspond with each other and let everyone know what's going on, especially when y'all trying to make these exchanges, because it doesn't sound like it sounds like neither of you have the best transportation. Hopefully, ma'am, like I said, after February of this year, you'll get something a little newer. Again, I would think a 2019 wouldn't be that bad, but obviously, if you bought it used, that could have been problems long before you got it. So yeah, got it. Anyway, folks, I'm gonna go ahead and let go off the record and let the state get y'all into a breakout room. Good luck to both of you and your daughter, and have some fun. She's 4 years old, and this is the year that she really gets Santa Claus. Okay, so you tell Santa, don't disappoint this child one iota of or associate judge in Texas will not be happy with it. Okay, thank you.
Yes, Your Honor.
Thank you.
Good luck, folks. We're off the record. All right, who's next, please?
And I do.
So I just wanted to bring up one thought that I had. Because you know how Attorney Tanaka, the dad's attorney, kept stressing that the mom had to give her phone number and address, right? The reason that was such a big deal was because the mom had provided dad with her phone number. Well, Attorney Tanaka and the dad tried calling the mom, and it wasn't a valid number. So while they're in that breakout room and mom gives her personal information and gives the phone number, they should call the number on the down low while they're in that breakout room and see if someone else answers the phone and it's not her. That would be hilarious. Oh, instant glorious contempt. Yeah, he really did. And honestly, I don't even think she realizes it. I don't think he did terrible. I really do love this judge, though. And we've got one more with him.
Have a hearing ready, Your Honor.
All right, what's the cause, please?
This one is 255361.
Yeah. How about 631?
Could be, Your Honor. Let's see. 255631. Yes, Your Honor.
Okay, I thought the odds of that those two have been out of place, or and a 200,000 one. Yeah, that's lotto odds. Okay. So, anyway, let me see what I got here.
This one
Mr.
might
Hernandez,
make
Ms.
some people
Villarreal,
mad.
this is your case. If you'd like to turn on your video.
Okay, I'm here.
Some of y'all might get
Motion on the
mad.
record, and this is Bell County cause number 255,631. This is the interest of Hernandez minor children, non-custodial party. Alleged at this time is Marcia and Villarreal. The custodial party is Cruz Justin Hernandez. This matter is before the court on a notice of change of status and motion for further orders. Is the state's allegation in this matter that Mr. Hernandez, who was originally named as the conservator, that was named as the conservator with the right obligation to pay child support and the right to visitation, and Ms. Villarreal was named as the custodial party in these children, that's no longer the case, that the children now reside with Mr. Hernandez and has done so long enough in conformity with the Texas Family Code to warrant the court changing that order at this time regarding custody, child support, and visitation. Anyway, the court will note for the record, both parties appear to be present. Both parties were served back in August of this year, so both parties are before the court in conformity with the Texas Rules of Civil Procedure. So at this time, I'll ask the state for an opening to tell the court what the state is requesting we do here today. The motion appears to say both children do reside with Mr. Hernandez at this time. So I'll ask the state to confirm that and tell the court what you understand any other agreements and contests to be. Thank you.
Thank you, Your Honor. There's very little agreement in this case. The state was understanding the parents who have agreed that children were with father since 2017, and so there would be possession credits up to that point. However, the state has provided to the court and sent out to the parties its payment history reflecting what Mr. Hernandez was ordered to have paid since the prior order was done in 2012. As well as a school letter, it appears the father provided, and an affidavit of possession claiming that the children were with him for longer. Going forward, Your Honor, the state has calculated support for each parent to pay the other, depending on what the court ultimately rules. However, the children do appear to be with Mr. Hernandez and covered through government medical through his spouse. at this time. And I do not believe, Your Honor, unless I hear something very different in the testimony that I didn't negotiate, I'm not sure that a final order would be appropriate today.
All right, here's the thing, Ms. Villarreal. You're not a lawyer. I get it, ma'am. Fortunately, I am. And under Texas Family Code, if you voluntarily gave him those kids for longer than 6 months, then he has the absolute right to ask the court to change the custody over him, change the status, what the state calls it. It's just a change of custody technically. And the burden of proof falls on you to show why I should not do it. Okay? The burden of proof is the only burden of proof he has to meet that it was a voluntary circumstance and he's had them for 6 months or longer. And then the law says it's up to you to show why I should not order that everything remain as is and order you to pay child support, so forth, so going forward. And I can make this a temporary order to give you the opportunity to go out and seek your own legal counsel. But ma'am, like I said, the burden now falls on you and or if you had a lawyer, your lawyer to show why the court should not change the status at this time. So at this time, I'm going to go ahead and swear you both in, get some testimony, see whether or not I'm gonna make this a temporary order and give you the opportunity to go out and retain counsel to help you in this matter if you can still afford to do so, ma'am. So at this time, I just want to give you a heads up. So at this time, I'll ask both you and Mr. Hernandez to raise your right hands, and ma'am, you need to unmute yourself. Thank you. You both of you solemnly swear or affirm the testimony you're gonna give here today is the truth, the whole truth, and nothing but the truth, so help you.
Yes, sir.
All right, you're both under oath, and you can put your hands down, and I'll let the state go ahead and call you both as witnesses where we can get some clarification on what's going on here. Thank you.
Thank you, Your Honor. The state calls Mr. Hernandez. Sir, what is your full name?
Cruz Justin Hernandez.
Who are the children in this case?
It's Mike Jake Hernandez and Cruz J Hernandez.
How are you related to those two children?
I'm their father.
Who is the mother of these two children?
Marcy and Burial.
And sir, at this time, who do the children live with?
They reside with me here.
In what county, please?
Bexar County.
And sir, how long have you and the children been in Bexar County?
Since 2015.
And right this second, sir, you are currently the person ordered to pay both child support and medical support to Ms. Villarreal?
Yes, ma'am.
And that order was the one in 2012?
Yes, ma'am.
Were you able to hear my opening statement to the court, sir?
Yes, ma'am.
Was that an accurate description of the issues were before the court to have it decide today?
Yes. Oh, they lived with me their whole life. But me and Marcy separated in April of 2016.
And so, sir, even though that's what you're saying now, the children lived with you their whole lives, you were still ordered to pay support back in February of 2012?
Yes, because my son, Mike Jake, was not on my...
Hey, sir, here's the deal. You don't have to explain why it happened. It's part of the court order. So there's,
Yes.
it's carved in stone now. That thing is 11 years old. So, okay, just that it was
Yes.
done. Thank you.
Yes, ma'am.
All right, sir. And is it correct that you had submitted some documentation for the court to show where the children currently are and where they have been?
Yes, I emailed Belinda Morales, and those are the documents I have right now. My wife went to go get the letter that me and Marcy Vero notarized in order for them to register them into Winston Elementary back in February 5th of 2017.
And Mr. Hernandez, I don't know if you had a chance to check your email before this hearing began, but one thing that was submitted was a letter dated April of 2023 regarding your children being in Bexar County. Do you recall that?
No, ma'am.
Okay. Do you recall submitting a document regarding an affidavit of direct possession indicating how long the children had been in your household?
My wife actually submitted that. She did mention about submitting the paperwork like that, but I never actually saw it myself.
Okay. And sir, under that 2012 order, you were ordered to pay the child support and medical support through the state's disbursement unit. Is that your understanding?
Yes, ma'am.
And so, sir, looking at that payment record, and Your Honor, at this point, the state offers an evidence states Exhibit 1, the financial activity report.
It's back in the very back. All right, folks, this is state exhibit number 1. This shows what monies have been paid or should have been paid through the state disbursement unit in this case. Is there any legal reason, sir, I should not allow this in evidence and review it?
No.
Ms. Mariella, any objection, ma'am?
No.
All right, state's one's admitted. You may proceed.
Thank you, Your Honor. Mr. Hernandez, that document shows that as of yesterday, you owed $67,541.94 in child support. Does that sound correct to you, sir?
Yes.
And sir, how exactly do your children have health coverage at this time?
My wife applied for Medicare, and she has them on Medicare.
How long has she been the person covering them?
Since about 5 years, since 2017.
And sir, do you recall what the coverage was for the boys back in 2012?
2012, it was Medicare.
And sir, why is it that the children were only put on your wife's Medicaid back in 2012? Or sorry, 2017?
Because my wife applied with my other 2 children that live with us. She put us all together, or put them all together as a family.
And sir, you had mentioned a notarized document between you and Ms. Villarreal. What year was that document notarized?
2017.
And so, sir, was there a reason that after your separation in 2016, it took that long for some documentation or written agreement between the 2 of you to be done regarding your children?
They were living with Marcy. They were living with Marcy at her mother's from the time we separated till February 5th.
And sir, is it fair to say that your request for the court today is that you be named the person able to decide where the children live and are no longer obligated to pay support to Ms. Villarreal, who would then be paying support to you?
Yes.
How many other minor children do you have, sir?
8.
How many of those children are in your household?
Besides Mike and Cruz, 3.
And for the remaining 5, sir, are you obligated to pay support for them?
Yes.
Will the oldest of those children turn 18 in the next 3 years or so?
No.
And sir, you understand that my colleague calculated support from you if the court decided to change where the children live, correct?
I'm sorry, my daughter will turn 18 within the next 3 years.
What is her exact birth date, sir?
It's October 20th, 2000. I'm sorry, she was born when I deployed, so I'm trying to remember. I get the dates mixed up. October 20th, 2008, maybe. She's 16 already.
Okay. And so she is the only one of your other minor children who would turn 18 in the next 3 years?
Yes.
Okay, thank you, sir. And sir, given this number of other children, you understand that the state had calculated that if these 2 children, your sons, were ordered to go back to live with their mother, your support obligation would be $269 per month?
Yes.
Do you have any concerns, Mr. Hernandez, about being making decisions with Ms. Villarreal if necessary?
Yes.
What are those concerns?
There's just some disagreements about them being at her house with the vicious animal, but that's pretty much it. I mean, other than that, she's okay.
And sir, back in 2012, you and she were named joint managing conservators of the boys, meaning you each had the same rights and duties with only a few specified for her. Do you recall that?
Yes.
And so, sir, would you have any problem if the court decided that you should be primary, naming you and the mother still joint managing conservators?
Yes and no, because I want them to go to a grade A school. I want them to attend certain courses
Yeah,
and
here's go, sir. Here's go, sir. If you're to name the party with the right to decide domicile, you get to pick the choose. You get to pick the school, sir.
oh yes, I would like to be the one to pick.
Okay, thank you.
Sir, do either of you have any criminal convictions?
Yes. When I
Which
was
of you?
me when I was younger.
Okay. And
Okay, anything since the kids were born, sir, the two children in this case.
No.
Okay, then anything that happened before then is not relevant, sir. Thank you.
Yes, sir.
and so no information about the mother's criminal history since the children were born?
No.
Earlier, sir, you mentioned your deployment during the birth of that daughter who's going to turn 18 in a few years. Did you separate from the military honorably?
Yes, I did.
And is some type of VA disability or military retirement being received as part of your resources?
No.
What has the visitation schedule looked like for Ms. Villarreal since the children have been with you?
It's open. She could visit whenever. We just asked that she let us know a week or two ahead. So that way we can make sure we don't have anything planned. But she's open to visit them anytime or to come over or for them to go over there.
And sir, what is the current distance between your two residences?
If she still lives in the same place, it should be 10 to 15 miles.
Okay.
So they live 10 to 15 miles apart, and she can't bring herself to go see her kids. But the last dad was willing to drive over 11 hours to see his daughter. Isn't that something?
So is it fair to say, sir, that you are each Bexar County residents?
Yes.
Okay. Anything else, sir, you want to consider going forward?
There are, when we contacted child support a couple of years ago to try to get the order changed, some of the arrears was taken out from a checking account, and we had asked if they could put it on a hold, which they were supposed to, and then they still sent it out to Marcy. But child support didn't know how it happened because it was supposed to be on hold. We just asked if that could be put in her arrears.
No, sir, it cannot.
Yes, sir. Thank you.
Thank you. Sorry, that's a little bit of too much of a U-turn, sir. Sorry about that. Thank you.
Yes, sir.
Thank you, Your Honor. I pass this witness.
All right, sir, I'll be right back. I'll be back to you in a few minutes. Call your next witness, please.
The state calls Ms. Villarreal. Ma'am, what is your full name?
Marcianne Villarreal.
How are you related to the two children in this case?
I am their mother.
And ma'am, is it correct that you were the person who was ordered to receive child support back in 2012?
Yes.
Were you able to hear my opening statement to the court?
Yes.
Were you also able to hear Mr. Hernandez's testimony?
Yes.
Would you agree, ma'am, that your children do not currently live with you?
I do agree. Yes.
When did that start?
I know it was sometime in 2017. I don't remember the exact month, but I know it was in 2017.
Do you recall what time of year as far as seasons or anything like that?
I want to say it was probably after New Year's because I had my daughter in March of 2017.
And at that point, ma'am, were you in agreement with your children going to live with their father?
No.
How is it that they went to go live with him?
He offered to take the kids for a week to, since I was about to give birth to my daughter, to help me out in that way, which I agreed would be for a week. But then we had talked about withdrawing them from school because he said it was a hassle driving where I lived to take them to school and pick them up. So I allowed him to do that to move schools to be easier for him. But I don't remember signing any notarized document about that.
And then, ma'am, when did you next attempt to get your boys back?
I didn't know where to go or how to proceed from getting them back. And I didn't want to call the cops on him or anything like that.
And so,
The
ma'am,
trickery.
when did you start visiting the boys after they had been withdrawn from their first school?
They would come with me very often. I would see them like on the weekends. He would let me see them. It just started, I guess I say a couple of years back, where I wasn't really able to see them because every time I would ask, it would always be a no, or we'll see. I have things to do.
Okay, ma'am, here's the deal, ma'am, here's the deal. Why didn't you just keep them? You had a court order.
I didn't know that I could because I thought it was a joint custody thing to where we would both have them.
Okay, all right.
Yeah, I did not know where to go from there. I'm sorry.
Okay, you may proceed.
Thank you, Your Honor. Ma'am, when you say a few years back, do you mean 2021, since we're in 2023 now, that the visitation became difficult?
I would say, let's see when. Probably about 2020, 2021. It's when the visitations became difficult.
And can you recall, ma'am, whether any of that was due to the pandemic and it being in full swing at that point?
No.
Has there been any change to that difficult drop-off based on what Mr. Hernandez just testified to?
No, there hasn't been no change.
And so, ma'am, when is the last time you had your boys in person?
The last time was probably before school shopping. They asked for me to buy the kids' school clothes and shoes, which I did. And when I took them to pick up shoes or to get shoes, my son was being difficult about which ones he wanted. So then I told him if we couldn't find anything this weekend, I could pick him up next weekend to see if we could find anything. And when I mentioned that, his girlfriend had said no.
And ma'am, would that have been in August or July or even September
Probably,
of 2023?
I would say July.
And so, ma'am, had you all discussed the holidays at all, or including electronic communication since in person wasn't happening?
I just know every holiday wasn't. I mean, I would ask, but it would have been a no.
How did you ask?
I would ask if they had plans and if I could see them, for at least Christmas Eve or Christmas Day, but they always have something to do.
And was all of this verbal, or were some of these requests written?
Mostly verbal.
Would you agree, ma'am, that the distance between your households is roughly 15 miles?
Yes.
And when exactly is the last time, ma'am, that anybody lived in Bell County?
That was a long time ago. I think we moved out of there after I want to say after my son was born.
Okay. So before the time you mentioned visitation getting difficult?
Yes.
At this time, ma'am, do you have any coverage for health or dental for your boys?
No, not at the moment.
Do you have any other children besides your son and daughter that you've already mentioned, and these two?
I do have two other that don't live with me. They live with their father, which was agreed on in a divorce.
And are either of those children going to turn 18 in the next 3 years or so?
Yes.
Sounds like a pattern for
May
her.
I please get a birth date for either or both of those children?
January 14th of 2007. And then May 13th of 2008.
And ma'am, would you agree that my colleague got information about, from you to calculate support if the court decides the children should remain with?
Address for that, August 5th, 2022.
Okay,
So
well,
he's been picking her up there.
Oh no,
here's
I
the deal, ma'am. Going
bumped it.
forward, it's your.
I'm so sorry.
2000.
why is it that the children were only put on your wife's Medicaid back in 2020? Would you agree, ma'am, that the distance between your households is roughly 15 miles?
Yes,
And when exactly is the last time, ma'am, that anybody lived in Bell County?
that was a long time ago. I think we moved out of there after I want to say after my son was born.
I'm so sorry, y'all.
Okay.
I hate when I do that.
So before the time you mentioned visitation getting difficult?
Yes.
At this time, ma'am, do you have any coverage for health or dental for your boys?
No, not at the moment.
Do you have any other children besides your son and daughter that you've already mentioned, and these two?
I do have two other that don't live with me. They live with their father, which was agreed on in a divorce.
And are either of those children going to turn 18 in the next 3 years or so?
Yes.
Okay. May I please get a birth date for either or both of those children?
January 14th of 2007, and then May 13th of 2008.
And ma'am, would you agree that my colleague got information about, from you to calculate support if the court decides the children should remain with Mr. Hernandez?
Yes.
And so based on the children currently having coverage for government medical through Mr. Hernandez's spouse, cash medical would be $63 and child support would be $483 per month.
Okay.
Would you agree, ma'am, that you and Mr. Hernandez should still be named joint managing conservators of the children as you were back in 2012?
Yes.
And that if this court set specific visitation for one or both of you, you could communicate well enough to ensure that the order was complied with?
I hope so, yes.
Was there anything else, ma'am, you were wanting the court to consider at this time?
No.
And ma'am, as far as the arrears that were owed on the case, would you agree that the time that the boys have been, well, that since 2017 anyway, when you first allowed the boys to stay, Mr. Hernandez should get a credit against the $67,541.94 in arrears the state shows him as owing?
Yes.
Okay. Thank you, ma'am. Your Honor, I pass this witness.
All right, then, anything on, as far as recalling Mr. Hernandez, Ms. Mongat?
Just briefly, Your Honor.
All right, go right ahead.
Thank you, Your Honor. Mr. Hernandez, do you recall, or were you able to hear Ms. Villarreal's testimony?
Yes, ma'am.
And do you recall the circumstances of how the boys came to live?
Yes,
how the
ma'am.
boys came, sorry about that.
I heard.
Was there any discussion, sir, about the reason for the children being withdrawn from one school and moved to another?
Yes, ma'am.
Why is that, sir?
Because they're gonna live with me. We wouldn't withdraw them if they were just gonna stay with me for a week. That wouldn't make sense. But I had to get a letter notarized in order for me to enroll them into the new school because I'm not on Mike Hernandez's birth certificate. But Cruz Hernandez, I was able to enroll him without that letter, and that they're gonna live with me, but it wasn't gonna be for a week, and Marcy did spend time with them throughout. She would help me. She used to help me a lot before. She used to stay at my house in 2019 during the summer. I used to go to work for a month or two, and she used to stay at my house, or vice versa. The kids will stay with her. But she never asked for them to come back to live with her or anything like that. She started a new life. So it was pretty much it with between her and the boys.
And Mr. Hernandez, do you know anything about the school shopping trip that occurred this past July?
Yes. She took them to get shoes for the kids. We were low on funds, and we had asked her to get shoes for them, but she wanted to take them shopping the next school weekend. Um, but the thing is, my kids were already starting school since they go to Great Hearts. They start early, so she couldn't take them the next weekend to go school shopping because they needed the school shoes before they started. Um, so that's why. And I think we had plans. We had plans for that weekend too. I think it was my grandfather who had cancer. I think it was his reunion, and we were gonna go to that before he passed away, which he already passed away.
Mr. Hernandez, did any of the children's schools require a copy of the orders that were in place?
No, no, just no. They didn't require any of that.
Because you mentioned you not being on the birth certificate for one of your children,
Yes.
Mike. However, that order clearly named you as a father or confirmed that you were the father.
Yes.
How, sir, do you and the mother communicate right now?
Text message.
And is that the only way, sir?
No, normally it's through text message, but if it's a last minute thing like the day before a holiday, she'll call me and ask me if she could visit the kids or pick them up. But usually we're not here, or we have plans already, and that's why we just ask for a week in advance to schedule something with the kids.
And Mr. Hernandez, what have holidays looked like since the children have been with you? What time, if any, does Miss Villarreal get?
She doesn't. She hasn't called. It's barely. Before she would call, and then like on Thanksgiving, we could share times. Like, hey, your mom got this, and my mom usually does stuff in the afternoon. So it's usually like they go there first, and then back to me, or vice versa. But this past 2 years, um, she hasn't really been calling. We haven't really seen any messages. I think it was in 2021 when the communication kind of just died out.
And sir, do either of your children have their own phones?
Yes, they both do.
Do you know, sir, whether Miss Villarreal has the numbers to either of those phones?
Yes, she does.
And sir, you had mentioned that you'd ask her to give notice of a week or so in case you have plans. How was that request or requirement communicated?
Verbally. Yeah, text messages.
Was there anything else, sir, you wanted the court to consider?
No, that was it. It just she hasn't been coming around for the past year. So she used to help out a lot. She used to help take the kids to school. She used to help watch them when me and my wife were working constantly. But then one time there was a dog, a pit bull, and we asked that she not have the pit bull there while the kids were there, but she refused to remove the pit bull. So we just kind of like got in an argument, and then it just kind of faded from there.
Thank you, sir. Your Honor, I pass this witness.
All right, anything of the other witness at this time, Ms. Mongat?
Briefly, Your Honor.
Right ahead.
I love dogs, but if it came down to seeing a dog or seeing my kid, sorry, kids. No, I'm just kidding. They got into an argument over the pit bull, and she just stopped showing up for her kids. Really? That just doesn't even compute in my brain. Yeah.
Villarreal, were you able to hear Mr. Hernandez's new testimony?
Yes.
Was there anything specific, ma'am, that you disagreed with as far as the details?
I mean, I would say no. I mean, no, I guess not.
And ma'am, at this time, is there a particular pet of yours that he objects to?
What do you mean?
That pit bull he mentioned, was that your pet?
It is our dog, and when the kids were here, he was inside of a kennel. He wasn't out roaming around. And I still do have that dog.
And ma'am, has that dog been yours since a puppy, or was it an older dog when you got it?
He's been here since a puppy.
And have there been any issues that were concerns for you, ma'am, based on him being around your other children or people in general?
No, I mean, he does tend to bark. All dogs bark, but other than that, no.
Anything else, ma'am, you wanted the court to consider that I haven't already asked you about?
No.
Thank you, ma'am. Your Honor, I pass this witness.
All right, then at this time, I'm going to allow the Ms. Villarreal to tell me anything else you think I need to know, and then I'm going to go to Mr. Hernandez. Okay, Ms. Villarreal, anything else you think I need to know at this point, ma'am? This is going to be a temporary order. I'm going to give the kids a lawyer because I've heard some contradictory information, and I'm going to give them a lawyer and get to the bottom of this, and we'll take that going forward. Thank you. But at this time, is there anything else you think I need to know, ma'am?
No.
All right. Mr. Hernandez.
Yes. We had in 2019, 2020, she was using the boys' names for food stamps benefits. And then again in 2021, I believe, she was using their names for food stamps, but they weren't living with her.
Here's the deal, sir. She had legal custody. You didn't. So, that was a court order. So that until I change that, that's that.
Yes, sir.
I disagree with the judge there. It's different in Wisconsin. But in Wisconsin, it's with who's living in your house as far as who qualifies for the food stamps, excuse me, or how much you're getting per month for food stamps. So even though she has primary placement of the children, if they don't live in her residence, if it were Wisconsin, she would not be getting those benefits. But apparently in Texas, the laws are different, or the judge doesn't understand how the EBT program works. Maybe that's a possibility. I mean, you can't know everything off the top of his head, but she's got the child support order. She's receiving food stamps and the medical benefits and stuff, and the kids aren't even with her. Like, ooh, I don't like her. I don't like her a bit. I didn't like the last mom either. I really don't like this one.
All right. Anything else, sir?
That's it.
All right, Ms. Mongai, anything in closing, ma'am?
Your Honor, given the court's preliminary ruling that this will be temporary in the appointment of an ad litem, the state seeks to hold the confirmation of arrears in abeyance, stopping support if the court makes Mr. Hernandez temporary primary person, and depending on which parent you choose to pay support, I'll reiterate those support numbers then, Your Honor.
All right. All right, here's what we're going to do, folks. I'm going to keep you both as joint manager conservators, with the right to decide domicile. I'm keeping that with myself. And for right now, I'm going to leave them with Mr. Hernandez. But right now, sir, you don't get to decide where they live. I do. If there's a change of circumstance, you need to let the state know and the attorney representing the children know. I'm going to go ahead and appoint Ms. Swartz as the ad litem in this matter because she lives closer to you than any other ad litem attorney I have. She's out of Austin, so she has to go to San Antonio. She can go to San Antonio or Bexar County if you're not in San Antonio. Sorry, not everybody in Bexar County lives in San Antonio, okay? Anyway, so at this time, I'm going to leave it as is, but I'm going to have her do this investigation. Here again, folks, the transfer of the children had to be voluntary. Right now, like I said, I'm going to leave them with her, with you, sir, but I'm going to give mom standard visitation. And here's the deal with standard visitation, sir. You are not allowed to make plans in violation of the mother's court order visitation, which are the first 35th weekends of the month. And I'm going to keep it at the 6 p.m. on Friday to 6 p.m. on Sunday standard, Miss Bongat. Moms to pick up and drop the children off at dad's residence. And going forward, obviously, they each of them get 1 week at Christmas, and that will be in the court order. But I'm gonna go ahead and order the standard visitation package going forward. I'm gonna go ahead and, like I said, appoint Ms. Swartz as the ad litem in this case, and have her do an investigation and find out what she's been able to find out. And then I'll probably need to set this for a special setting. So I'm gonna set it for a pretrial about 6 to 8 weeks out, where we'll see how much longer she needs to come to her conclusions. And then I'm gonna set it for a final hearing special setting where you're the only case I hear, because again, what the law is, there had to be a voluntary transfer. And if it was a voluntary transfer to the other party, and then the burden of proof falls on the mother, and why I shouldn't change things around. If it wasn't a voluntary transfer, then the burden of proof falls on dad, why I should change it around. So again, I'm gonna let that light and finish her investigation, and we'll figure this one out. So at this time, I'm gonna go ahead, like I said, name you both joint managing service, keep the right to decide domicile with the court. And I'm gonna see everybody back here on a pre-trial. You got anything showing when Ms. Swartz is gonna be here in late January?
Yes, Your Honor.
Okay.
She will be in this court on, you said late January?
Yes, ma'am.
Okay.
Well, mid to late, I need to give at least 30 days, which she's not in vacation mode, so holiday vacation mode.
Yes, Your Honor. We have her on both January 18th and January 25th.
All right, let's go ahead, and it's a pre-trial, so let's go ahead and do it January 18th. At that time, I'll find out how much longer she's going to need and whether or not the parties have lawyers, and then I'll set that up for a final hearing and special setting after that date. So again, folks, I'm going to go ahead and set this up as a temporary order. I'm giving the children a lawyer, and I'll see everybody back here for the pre-trial on January 18th. Like I say, the person appointed to represent your kids his name is Elizabeth Swartz. I'm going to have the state confirm that it's okay with both of you that she give Ms. Swartz your phone numbers and addresses for the purposes of contacting you and to talk with her clients. And get everybody back here after the first of the year, where I can set this thing for a final hearing and then get her report on what she's been able to find as far as the circumstances are concerned. So at this time, I'll start with you, Ms. Valerie. I'm not ordering any child support. I'm going to hold in advance the binding on the arrears, and because again, that's all going to be affected by whether or not the transfer was voluntary or not. So at this time, Ms. Villarreal, any questions, ma'am, or anything else you're asking the court to do here today, ma'am?
No, I am currently pregnant at the moment, which a high risk pregnancy, which my child will be due sometime in February or March. I just don't want it to be, I guess, intervened during those times.
Okay.
Like to go to court, yeah.
Okay. Well, I'm looking at. Well, you can tell us. You can tell us a little bit closer to the. We'll be a little bit closer to the due date when we come back in January, and we'll work around any medical circumstances, ma'am.
Okay. Thank you.
But is there any problem right now with you picking up your kids for your visitation packages?
No, I don't have any problem.
All right. Thank you.
Thank you.
And ma'am, you could use a designated agent to pick them up, so long as the person's over 18 and has a driver's license. Okay.
Okay. Thank you.
All right. All right. And I'm also going to order everybody to get AppClose, the parenting app, as iTunes and Google Play. I want you both to use that to communicate going forward. And that way, if the ad litem needs to get a copy of your text messaging or anything under that, she'll be able to do it. So it's APPCLOSE. It's going to be in the court order. You both need to download it and register. And like I say, going forward, when y'all communicate to each other, use the chat function or the text message functions in AppClose. And I'm not looking to do any FaceTime because y'all live close enough to each other, so I don't have to worry about that. All right. So Mr. Hernandez, question, sir?
No, sir. I have a son who doesn't want to see his mother. What do I do in that case?
Still, sir, I don't let kids tell me what to do. I'm a grown man and I'm a judge. Sure. Kids don't run these things. I do. And yes, you tell him the judge says that that's his mother. He's got it. And he doesn't get a say-so in this, and he can talk. He has a lawyer. You can tell his lawyer this, but see, Ms. Sir, when I hear things like that, I think that you might have more of a hand in that than the child did. So again, I may be 100% wrong, But 90% of the time, that's the case. The parent has influenced the other child against the child against the other parent, and I'm not going to put up with that. Okay, but again, kids don't tell me what to do, and they sure as heck shouldn't tell you what to do, sir. Again, you're the parent. All right, so that's that. Anything else, sir?
No, sir.
And again, don't you'll get a copy of the order with the visitation package in it. Do not schedule anything on mom's visitation. Like I say, it's that first, third, and fifth Fridays of the month from 6 p.m. on Friday to 6 p.m. on Sunday. Which, in other words, this coming weekend is her weekend coming up. This is the first Friday of the month, okay? And no, it's not. It's the second one. Sorry about that. So it's the following weekend after that. And there's 1 week at Christmas, and I'm not sure if this is her year to get Christmas Day or the week get New Year's Day as part of her package, but it's in there. Okay. All right. All right. Anything else, Ms. Mongat?
Yes, Your Honor. Can this order reflect that the children have government medical through Mr. Hernandez's spouse?
Yes, it can. And if y'all have any questions about the visitation package or you need a clarification, y'all could both ask the ad litem. Again, she doesn't represent you; she represents the boys. But she won't lie to you about what the circumstances are as far as the court order is concerned. But if you do want your own legal advice, you do need to seek your own legal counsel. All right.
Yes,
All right.
And then, Your Honor, with regard to Ms. Schwartz's appointment, given the children's ages, is she an amicus?
Yes.
Yes, Your Honor.
All right.
Thank you, Judge.
That's all legal mumbo jumbo to say that she's their lawyer, but they can't tell her what to do as their client, as her clients. Okay, she gets they can tell her, but as her, she has her own free will to make a decision. Going, no, that's not in your best interest, and I'm not going to do it. So, okay. All right, folks. I'll see you back. I'll see you in January. Is it okay, Mr. Hernandez, that the state give the lawyer your contact information?
Yes, sir.
Ms. Villarreal, is it okay?
Yes, sir.
All right. Thank you both very much, and I'll see you in January. And y'all have a happy holiday, safe holiday. And well, I would say don't tell Santa not to overdo it, but there's no such thing. So there you go. Anyway, thank you both very much, and we're off the record.
You guys gotta go. You can't go with us.
All right. May the parties be excused, Ms. Bongat, or do you need to take them back in a breakout room for anything?
No, Your Honor. Parties are free to leave the meeting.
Y'all free to leave the meeting, folks. I'm finished writing this one up. Thank you.
All right. That was a fun one. I did get a few requests to explain food stamps for the people who are not in the United States. And it's just a government program that people are issued a card, like a debit card, basically, that is loaded with a certain amount of money every month. And not everyone has issued it. You have to go through an application process, and based on your how much income you have, the area you live in, certain demographics, there's so many things that are calculated into the budget of how much you get. I mean, it's just it's impossible for someone like me to keep track of all that. But I know there's a lot of factors that are considered. And then every month the people get whatever their allotted amount is loaded onto the card, and it can only be used for food, nothing else. And in addition to that, it can only be used for cold food. So, for instance, you can go into a gas station and purchase a slushie with it, but you cannot purchase a coffee. That's hilarious. You can purchase a deli sandwich, but you cannot purchase a slice of pizza. Anything that is cooked already and hot is not allowed. Now, if it's pre-cooked and then refrigerated, like leftover type, like when they clearance off rotisserie chickens or something like that from that were previously in the hot case and now they're in the cold deli, you can get those. So yeah, it's just a government food program. Oh, see, some places allow hot foods. There's a lot of restrictions. No hot food. At least not in my state. And I've never heard of it allowed in other states. I thought that was at the federal level, but not hot rotisserie chicken. You can get rotisserie chicken that has been put into the cold deli case after it's been sitting in the hot warmer for hours. Yes. Not automatically. They're not specifically tied together. I mean, most people have both. But I don't believe that they're an automatically tied thing. I might be wrong on that. Because I know food stamps is specifically income based, but Medicare has or Medicaid has more qualifications. Like you have to have a child, and maybe the rules have changed, but years ago, you couldn't be, a 19-year-old single woman with no children and get Medicaid or Medicare. So, like Papa Murphy's. That's how it is in Wisconsin, at least. So, yep. That explains it, that it's state by state. So, yeah, there's no way that I would know anything about what other states do, just what Wisconsin does. You're welcome, sweetie. I wanted to wait until the case was over. Otherwise, the angry mobs come out. I get called lots of nasty names in the comments and things like that. So, yeah, you have to go to the courthouse or the social services building and fill out applications and give them all your income info. You have to provide your last 3 pay stubs, and there's all kinds of stuff involved with it. Oh, that tickles. It's so freaking cold. 10 degrees, but it feels like 0. I hate wind chill. Okay, I can handle cold, but I can't handle the wind chill cold because it pierces through your clothing. Okay, guys, I got one more, and then April's gonna go night. But I promised another AprilSeering exclusive. And I found it. Now the very first one that it starts off with, that one's funny, that one's good. But you'll know when the come on. That was the last one. What did I name it? See, I really got to stop trying to be clever with my names. Oh, yeah.
December 1st, 2022, February 16th, August 16th, October 11th, and November 22nd, all in 2023. You were finally picked up in December, on December 11th. So I wouldn't revisit that here today. In my division, you have to work pretty hard to have a $2,000 bond on a cash. But on a traffic case, I'm not going to find that anything other than what the current bond is appropriate. I just have a sneaking suspicion we'll be on failure to appear number 6 or 7, and I'll have to have the sheriffs come find you again. I'm just not interested in that. So I'm not going to revisit the bond here today. No new offenses against state, federal, or municipal laws. Appear at all future court dates. Do not drive a motor vehicle without a valid license and or proof of insurance. The next court date, I'll appoint the public defender if you remain in custody.
Is there any more information you could give me by chance? Because I didn't even get to talk to my attorney.
Well, I'm going to appoint them now. I wouldn't revisit that here today. But Ms. Blyler, do you have an opportunity to talk to him right after this proceeding, or can you let Ms. Frazier know or Mr. Morales know that he needs to talk to them? It's not going to change my decision today.
I will email the PDs is this a Division 6 case?
Yes, it will be.
Okay, I will email those PDs and ask them to reach out.
They're going to reach out to you, but it wouldn't do any good today. I'm not interested in chasing you down again. In custody, December 22nd at 9 a.m., out of custody, January 29th at 1 p.m., $2,000 cash or surety bond in this case.
So I have a chance to hopefully get a PR bond by my next court date?
No promises. You can file any additional motions, but we'll have to see where we are and what arguments I hear. But again, that's 1, 2, 3, 4, 5 failures to appear, and the case dates back almost an entire year, actually an entire year. And so I'm not making any promises. Your promises to appear, you haven't upheld those. So I'm not going to make you any promises about what I'm going to do with your bond.
I actually remember quite a while ago that I went to court and I got off of papers. Actually, I don't know if you remember that or not.
No,
But
I don't. I don't know that it's this case because we keep pretty good records. We actually record everything and we keep pretty good records because we don't want that to happen. I don't want you to get arrested on something that you resolved, but I'm not showing that on this case, okay?
yes,
So I
sir.
won't revisit that today, but we'll see you on December 9 a.m. with your attorney. Thank you.
Your Honor, what was the out of custody date?
Out of custody, January 29th at 1 p.m. in Division A.
Your Honor, next I have Juan Tarango.
Okay. Portal call People versus Juan Tarango, 23 CR 132 and 18M 1231. This is in a different posture. Mr. Tarango, you're here on what's called a no bond hold warrant because they're alleging that you violated the terms and conditions of bond. Miss Blyler, have you had an opportunity to talk to him about this, or maybe someone from your office?
Yes, Your Honor, I was able to speak with him about this. He is asking to confess the motion without admitting any of the allegations therein, and we're asking the court to set bond.
Okay. You understand that, Mr. Tarango? That's what you want to do. In other words, you don't want to make an admission that may get you in hot water in another context. I don't know that it would, but you'll confess without admitting so that the bonds can be vacated, and then we can set bond that you might be able to make. You understand that?
Yes, sir, Your Honor.
All right. So let's see. The court will revoke I think it's a $6,000 bond. Let me look. My notes are not as crystal clear as I would like them to be.
I believe they were both PR bonds.
That's what I'm seeing on the 18M 1231. I think it was a $6,000 PR. So I'll revoke the PR bond, and then it's a $1,000 PR bond on 23 CR 32. Miss Fatzinger, argument on that?
Yes, Your Honor, we would be asking that both be straight conversions to cash surety bonds. There are 2 pending cases. There have been multiple chances at PR bonds and more than 1 no bond hold at this point. There are 18 scheduled UAs. None of them were tested negative. All but 1 were missed, and the one that wasn't missed tested positive for meth and THC. Pretrial services tried to contact him extensively about indigent applications and missing UAs, and they had no luck getting him to come in and test except for that one that was positive. So I think converting these to cash surety bonds would be appropriate.
All right, Miss Blyler.
Thank you, Your Honor. Mr. Tarango well, he was born in Colorado. He's lived in northern Colorado for the past 10 years. Both of his daughters live here in Colorado. Their ages 14 and 3 years old. He does have shared custody of them with their mother. However, right now, Mr. Tarango's living situation, it had been a little influx. So his daughters were living with their grandmother. Mr. Tarango is able to live with his friend. He's already discussed that with him. He lives here in Greeley. That is a clean and sober place, a positive support system for Mr. Tarango while he gets back on track. As far as the UAs, while there are the allegations of a number of missed UAs,
He did
Mr.
meth.
Tarango was working full time during this time. He still has that job. He's hoping if he's released. And when he was supposed to take his UAs, he would often be late. Behavioral interventions, BI, closes earlier than going to community corrections for his UAs. BI would be closed, and then he would have to get a ride to community corrections, and then often would not have enough money. So because it does cost a little more at community corrections than at BI. So he was making efforts. He was generally keeping in touch with pretrial services, leaving messages, trying to stay in contact with them. He does recognize that he needs to do better in the future on pretrial services, and that is part of the reason he is in jail now. But he is asking the court to consider setting bond in both cases at $100 cash only. Thank you.
All right, and I have reviewed that. I think we're past that, and I think every time that occurs, it seems that the defendant doesn't take advantage. Looks like it was re-extended a few times, and then we have someone who's just basically not going to do what the court orders.
Okay, everybody, the star of our show has arrived. I know the previous couple have been really funny and really good to watch, but keep your eye on the guy on the bottom.
Certainly, Judge Doak can look at it differently than me, but this is one of those times where I think a straight conversion is the only option. I often cut it down if I think there's mitigating circumstances. I don't see them here. $6,000 cash or surety, appear at all future court dates with pretrial services, report to their offices within 24 hours thereafter on a schedule, and as directed, no drugs or alcohol except for medical marijuana, prescription medications, participate in and pay for substance use monitoring as directed. Sign and comply with the protection order as well as the relinquishment order. Do not violate state, federal, and municipal laws. Comply with any and all conditions of court-ordered community-based supervision. Do not drive a motor vehicle without a valid license, and report to probation within 24 hours of your release. And the other one, it'll be $1,000 cash or surety. I'll find that that's the only real reasonable option given the history and the lack of performance on pretrial services. Appear at all future court dates, report to pretrial services, and thereafter on a schedule. Do not possess, use, or consume drugs or alcohol except for medical marijuana, prescription medications, participate in and pay for substance use monitoring, comply with the mandatory protection order, do not violate state, federal, or municipal laws, comply with any and all conditions of probation, do not drive a motor vehicle without a valid license. Now, one of these is a revocation, the 18M1231. I'll appoint the public defender on both cases. Ms. Blyler, have you talked to him about the prospect of waiving the 14-day rule in that revocation case?
I did. Yes.
You did? Okay. So, Mr. Tarango, sounds like you may want to set these together in front of Judge Doak with the public defender. Is that what you want to do? Waive the 14-day rule rather than set a contested hearing immediately or within 14 days?
Yes, Your Honor, I'll go with the recommendations of my public defender.
Okay, thank you. All right. Court will set the matter in custody or both matters January 12th at 2 p.m. in Division 5 with the public defender. Find the waiver of the 14-day rule. Appoint the public defender in each of the cases. If you post bond, February 22nd at 1:30 in Division 5. And you may need to reapply. Let's see. One of them is April 23rd and the other is April 25th. That'll be, I would think, good enough, Ms. Blyler, unless your office says otherwise, but that's something that your office can take up with Judge Doak. You'll be in front of Judge Doak. Mr. Tarango, good luck.
Okay.
This is Walter Tullis.
Court will call People versus Walter Tullis, 20. Sorry, the case number's not right on there, but it's got to be 23, right? 23M3551. Hello, Mr. Tullis. Are you now or have you ever been in the U.S. military?
Oh,
Thank you. Did you understand your rights in the advisement?
I didn't answer because I didn't understand them.
So did they play a video for you or no?
They didn't give me a paper.
Okay, usually they put you in front of a video and have you watch a video. Did that just not happen?
Correct.
Okay. First of all, you're charged with obstruction and criminal trespass in the 3rd degree. Do you understand the charges? Yes or no?
No.
Okay. I don't want you to take this as an invitation to respond, but they're indicating that you were on somebody's land where you weren't invited, on somebody's property. And then when the police began giving you lawful orders, you disregarded those and continued to walk away from them. Do you understand that?
Yes.
Okay. All right. I will issue the Title 18 protection order. Do not harass, molest, intimidate, retaliate against, or tamper with any victim or witness. Mr. Tullis, you have the right to an attorney. That includes the right to a free attorney if you could not afford one. The assumption is if someone is in custody, they cannot afford an attorney. And so the public defender has been appointed while you're in custody. That's no longer an assumption once you get out of custody. If you can afford an attorney, you can always hire your own attorney, or you can reapply for the public defender, and they will apply objective criteria to your financial circumstances and decide whether or not to appoint the public defender to ask.
I don't know what's happened because somebody walked in while you were talking and distracted me, and I lost focus of what you were saying minutes ago.
Okay. Would you like me to start over on the advisement?
No, I'll take a lawyer because I have no idea what's going on, how this works or nothing. So without a lawyer, I don't stand a chance.
No, I understand, but I still have to make sure you're advised of your rights before we can go forward and before I can set bond. So I need to advise you because you're saying that you were not advised by video.
Y'all, even at this point, with as wackadoodle as he's acting, he's still smarter than most sits.
So I want to make sure that I go through what's called the Rule 5 advisement, okay? All right. You do have the right to an attorney. And if you could not afford an attorney, one would be appointed to represent you. The assumption, if you're in custody, is that you would not be able to afford an attorney. And so that's why Ms. Blyler is here today. She's appointed while you're in custody. When you bond out, when you get out, if you want an attorney, you'd need to reapply for the public defender if you want a free attorney. They apply objective criteria to your financial circumstances to determine whether their office should be appointed. That would remain so long as you couldn't afford an attorney, even if you were out of custody. You have the right to remain silent. Anything you say can be used against you in a court of law. So your attorney doesn't want you to make any additional statements. Really, today, it's just for me to make sure that you're advised and to see where we're going to go from here and to set bond conditions and the like. You have the right to be released on bond and to be informed of those bond conditions. I will make those determinations based on the paperwork I have, but everything that I witness and everything that goes on before me, you do have the right to a trial, a right to be presumed innocent until proven guilty to the unanimous satisfaction of the jury beyond a reasonable doubt. That includes your right to confront witnesses, cross-examine witnesses against you, the right to testify, the equal right to remain silent, the right to call witnesses on your own behalf, subpoena those witnesses, and if convicted, you have the right to appeal. By appearing today, I want to make sure that you understand those things. Do you have any questions about that, Mr. Tullis?
Yes.
Okay, what's your question?
I don't understand any of it. You're rattling off too much stuff for me to understand. It's just
Well,
too much information all at once.
If I don't get through this, then there's a chance the case is going to be set over to tomorrow. So what can I do to slow down and help you understand? How can I help you understand what I'm saying and get to the next step? Because I don't want to just set it over till tomorrow.
Well, you're telling me that I have the right to do too many things. You know, I'm very good if I have one task, I can figure it out. But you're giving me, like, you're just feeding me. All right, I don't understand none of these court proceedings at all. And you're just like bombarding me with information and it's just creating mass confusion. Just give me one yes or no question.
Okay. Do you understand you have the right to an attorney?
Yes.
Do you understand that you would be entitled to a free attorney if you could not afford one?
Yes.
Do you understand that that's automatic when you're in custody? You can't afford a lawyer if you're in jail. Do you understand that?
Okay, I see that.
Okay, and then if you bond out, we just have to see what kind of money you have before we decide can or can't afford an attorney. Do you understand that?
Yes.
You have the right to a jury trial. Do you understand that?
Yes.
That includes requiring the jury to hear the case and the people to prove you're guilty. Otherwise, you're presumed innocent and you remain innocent. Do you understand that?
Yes.
That means that you could testify at trial or remain silent at trial. Do you understand that?
Yes.
If you remain silent at trial, I would instruct the jury, you can't hold that against Mr. Tullis. Do you understand that?
Yes.
You have the right to call witnesses. In other words, if there was someone that you think could help your case, you can put that person on as a witness. Do you understand that?
Yes.
Sometimes someone can't just show up because you ask them to. They have a job that requires some sort of legal excuse to miss work. Do you understand that?
Yes.
For example, if someone wanted me to testify as much as I wanted to, I'd have to be subpoenaed so that I could get someone to take on my judicial responsibilities when I go to testify. That's called a subpoena. Do you understand that?
Yes.
So you could subpoena witnesses who might not be able to show up just because you invited them. Do you understand that?
Yes, that's like it's like politely forcing them to come.
That's like being gently forced to go to trial. That's what it's like. They wouldn't use force on you, but they would hold things against you if you didn't show up. Now, they also can put witnesses on against you. Do you understand that?
Yes.
You get to question them. In other words, you don't just stand by what they say in front of the jury. Your attorney could question them. That's called cross-examination. Do you understand that?
Yes.
At the very end, the jury would make a determination. Generally, there's an exception to it, but generally it's guilty or not guilty. Do you understand that?
Yes.
If you're found guilty, you could be sentenced by the court up to 120 days in jail on obstruction. Do you understand that?
Yeah. Okay. No, I
Ten-
mean, I understand it. Yes.
You didn't, but now you do, and I understand I was going too fast, so I'm going to slow it down. Trespass is punishable by 10 days in jail. That's the maximum penalty could be imposed. Do you understand that?
Yes.
And then if convicted, you don't have to accept that. You can appeal to a higher court. I'm a county court. I get reviewed by the district court. Do you understand that?
I don't understand the difference. I understand how the concept, but I don't understand county court and district court. If as long as them two things aren't important, I understand.
I suppose it's not as important as you understanding you have the right to appeal any adverse rulings. If you think the judge made a mistake, you can ask someone else for a second opinion on that. Do you understand that?
Oh, you lost me on that one.
Okay. So if you go to a doctor and they give you advice you don't like, you can go to a second doctor and get a second opinion. It's the same sort of thing, except that someone who reviews my decisions carries greater weight. They can say Judge Briggs was wrong, and they can overrule some of my decisions. And the attorneys were responsible for completing that process. So those are your rights that you have here today. All right, Mr. Tullis?
Yes.
Okay. Does either side have an objection to a PR bond with pretrial services?
No, Your Honor.
Any objection to that, Ms. Blyler?
No, thank you.
Yes, and Ms. Blyler, up until about a year ago, I would appoint Bridges as a condition of bond. The error in my ways was pointed out. I can't do that because it's voluntary, but I would invite a referral so that Mr. Tullis can get some additional assistance when he's out in the world. Our job is to help you get the resources that you need. You're going to be released. You do have to check in with pretrial services. All right. That is an off town that will help you with your court dates and that sort of thing, Mr. Tullis. So it'll be in the paperwork. That's the most important thing. You asked for one at a time. Pretrial services is an officer that helps you appear and keep your court date straight. Okay?
I already forgot what you said. So many things. I'm confused.
I thought I slowed down good enough for you.
I don't mean no disrespect, but you thought wrong, just like I do.
Okay. Well, I'm not going to keep you in jail. Unfortunately, if you don't follow up with this, look at the paperwork. And right now, the only thing I'm telling you is report to pretrial services and come to your court dates, okay? Your next court date. What is it or where is it?
Like, what and where is it?
It's at 901 10th Avenue in Greeley. That's going to be on your paperwork. It's right across the street from the court complex. You go there, you tell them your name, they'll take it from there. They'll sit you down and they'll take it from there. And the last thing they'll do is remind you of your court date. All right? You do have to comply with all state and federal laws. and the protection order.
Means I
My
have to
hope
learn
is,
all the state and federal laws.
I understand it's not an easy thing. I can only do the best that I can do, and I'm trying to help you as much as possible. Now, I show this as Division 6 appearance. It should be A, but I think I'd like to keep it in here so that he doesn't have to wait for the arraignment to get a public defender, Ms. Blyler. I hope your office will go along with it. I just think that if you can perhaps get an attorney on board, I think he'll feel a lot better, okay? Also, seems to be doing the best he can, and so I want to recognize that a little bit different than what was portrayed in the affidavit, and so I'm trying to do the best that I can. The next court date out of custody in Division 6 will be February 27th at 9 a.m. I'm hoping you'll have an attorney by then. I don't know, Ms. Blyler, if you can maybe give him a quick phone call or have Ms. Frazier do that, but there may be some sealed motions that need to be filed. Let's get your office on board. If you can do the application, even while he's in custody, I just think that would be the best option, okay?
I agree with the court on that. I am not sure if we need to wait for that application. I can see if I can get someone out to the jail to do that application now.
All right. Mr. Tuck, custody, where do you work? Do you work right now?
I don't have to work anymore.
So you don't have a job currently?
No, I don't have to work, and I don't feel comfortable telling you how I get my money.
Okay, never mind. I was gonna try to appoint a
It's
public
nothing,
defender,
I
but
swear, it's nothing illegal. It's just, I mean, I
No,
would
it's
tell
fine.
you personally, but I don't
It's
I don't
fine.
know who's listening, and I don't want
Sure.
everybody to know my problems, but I will tell you personally.
No, it's okay. You just file an application for the public defender and we'll base it off of that, okay? Next
Yes,
court
sir.
date is February 27th at 9 a.m. That'll be it for today. Thank you. Oh, it'll be a $2,000 PR bond, personal recognizance. Thank you, Ms. Blyler. Thank you, Ms. Fatsinger.
Thank you. Is there anyone else that we need?
Nope, that's it.
Y'all, at that moment, the judge was so done. He had the patience of a saint through that. I give so much props. The reason I couldn't find the clip was I had named it Best Judge Ever. And I forgot that I named it that. But that's exactly what went through my mind after that clip. Oh, wow. Yes, please tell us. Lucy's looking for tips. Yeah. If the judge was like, over it. I think my favorite part was was when he told the judge, "You thought wrong, just like I do." Oh my gosh. Mhm. Yep, another AprilSeering exclusive that you'll never see on another channel. That one is all mine and only mine. palms. The palms love my laugh. We're all there with you, Lucy. We're all there with you. Oh. And April's still awake. I got to sleep on my ride home from the doctor's appointment, so that was kind of nice. Yeah. So currently in line, I have another procedure on my spine, and then they have to do surgery on both of my feet, obviously at different times. So those are on the books. Yay. Well, Tink loves my laugh. Where's April? April and Tink should be here cuddling. It's okay. Maybe I'll be better when they're all done with me. Oh, that's not the one that I wanted to highlight. I'm sorry. That's the one that I was laughing at. Oh, Kiki Blue Honey, I got hit by an SUV about 1.5 years ago, and I got a really bad spine injury from it. That's why I'm in a wheelchair sometimes and can't walk much at all. And yeah, fun times, but it's all good. Of course you can, Tammy. Let me call her. Well, Ava. She's by her fireplace. Let me move my coffee. Ava, who's the prettiest girl? Who's the prettiest girl? My mama roll out of the way. Who's the pretty girl? Who's the pretty girl? Who's the pretty Ava? Who's the pretty Ava? Come on. Come on. There's a good girl. That's a good girl. You're the star of the show. You're the star of the show now. Yep. Beautiful Ava. Oh, beautiful Ava. She's so pretty. Give Mama kisses. Oh. She went under the chair, y'all. And then there is my baby sleeping on the other laptop. My big boy. That's my love. Hi. Hi, sweetie pie. Oh, funny. Your phone just knew. Tell me what brand it is so I can get all my subscribers to get that brand. It just magically opens April. Well, the kitties are gray and white, both of them. They look black on YouTube, apparently. You're not the first person to say that. Ava's black and white with a little brown on her, a little bit. She's red bone coonhound and Australian shepherd mix. And then the kitties are just domestic short hair. Of course. Yeah, I'm happy with it. It's just the lighting. I've got the worst lighting ever. I swear. I have to have the light above on, but then I also have a lamp over on my desk up there as well. Well, there's in the Discord, there's a the Discord has a Paw Pets thread. So you can put your baby up there anytime. It's, you know, the paw firm, Paw Pets. Yeah. You can see the red bone coonhound in her face, but her coloring is so Australian Shepherd. Yeah, except for you're a long hair. I've seen that beard. Oh, your comment actually just reminded me, because Paul Meyer Productions, he's one of my biggest fans. He really does not like Discord, but he sent me a gift from Amazon, and I don't know what it is yet. I haven't opened it, but he did tell me that that it was okay for me to open it even if he wasn't on. So give me 2 seconds. I'll be right back. So yay for unboxing. So usually these have a quick tear. I found it. Maybe not really. Oh, that's not the right one. Go. Y'all, this is my scissors. I keep it in my purse. Okay, you see this? Yes, this is my scissors. And dang, things are sharp too. Oh, cool. Oh, that's so awesome. Okay, so I got my mouse from Becky D, which I absolutely love it. And Palmyra sent me another mouse for my other computer. So now I have a mouse for each laptop. Oh my God, that's going to make editing so much better. And it's going to make my back so much happier because currently when I have to edit on the computer Billy's sleeping on right now, I have to lean like all the way across my desk at a diagonal to get to the mouse pad. And yeah, this is just awesome. Oh my gosh, I can take them off my wish list now that I got one for each computer. I'm so happy. Oh, Billy is on the keyboard. Billy. The flashing comment was Billy. Oh, that was so funny. I don't even know what comment it was. Whose comment was that? It was Stephanie September Anderson's comment. Oh my gosh, that was so funny. But yes, thank you, Palmyra Productions. Again, thank you so much. You've been amazing, and I appreciate you so much. I appreciate all of you, every one of you, from those who have sent me Cash Apps and PayPals and Venmos, to those of you who have just shown up and liked and commented. You guys are the best. You really are. And I am so grateful for every single one of you. And I mean that from the bottom of my heart. Seriously. You all are just phenomenal. So grateful to have you in my life. And I have a toolbar. Oh, I know what this is. Oh, no, I don't know what this. Oh, there we go. I got rid of it. Ah, good. All right. I know. No, he can't. No, he's back to sleeping already. He is back to sleeping already. Oh. Well, we officially know who's Billy's favorite. And you didn't even have to give him treats. Oh, you guys are just the best. So, I have to go potty real quick, but I'm not tired yet. Should I put another clip on? Should I stay up and just put another clip on? It's only 1:44. Oh. Hey, Billy's got tons of stuff on the wish list, especially the cat food, because we just ran out of it. And I got a couple weeks till payday, so he's really mad at me because he prefers the wet food. Earl likes the dry food, and I've got a whole bag of that. So he's not going to starve. But for a couple weeks, he's not going to have any wet food, and he is not thrilled about that. Just like Ava doesn't have any treats, and she is not happy with me. Oh, good night, Laura, sweetie. Thank you for coming out. Billy would love that. Billy would be very, very happy. All right, let me see what I got for clips. Because I know I clipped a whole bunch of stuff today. All right. I don't have a conclusion to that one yet. They haven't done the next docket. I'm gonna wait on that one. You'll love this.
Fun.
Good morning, Your Honor.
Good morning.
All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled "In the Matter of the Marriage of Tammy J. Millington, Petitioner, and Belgrave M.L. Millington Sr., 22 DM 116. Will counsel announce appearances, please?
May it please the court, Your Honor, Tammy Millington appears in my office and through counsel Christine Campbell with Franklin Law Office, both via Zoom.
May it please the court, Mr. Millington appears via Zoom, and Deborah Thompson appears on his behalf.
All right, thank you, counsel. We're set today for bench trial on the petition for divorce. I did receive via email a number of communications between counsel, including a respondent's motion to continue the trial. Counsel, have there been any agreements or anything regarding these motions or the status of the case?
No, Your Honor.
No, Your Honor.
All right, Ms. Thompson, do you still wish to take up your motion to continue?
Yes, Your Honor, and I also have a motion to withdraw and file with the court as well that was emailed at the same time.
Okay, I do have a copy of that, but let's first take up the motion to continue trial.
Okay. We appreciate it, and thank you for taking that up beforehand. The main reason that we are asking for this continuance is that Mr. Millington is currently in South Africa for his job as a U.S. expatriate employee. This is not new, but it has increasingly led to a number of technical difficulties in my ability to communicate with him. Therefore, it is my position and Mr. Millington's position that this hearing should wait until he returns from that job. This is the second time that we've had to request a continuance, and I know that it's tried opposing party and her attorney's patience, and I'm sure the courts as well, but it's because of the issues related to his employment and location in South Africa and our ability to communicate, which just, I think, shows the court how frustrating and difficult this has been. His job contract ends in July of next year, but it is an at-will contract and could terminate at any time. And so we believe that the continuance should be granted so that he can have time to complete that job or to make significant travel arrangements to come back and deal with the divorce. Mr. Millington is not a current active member of the military, but obviously given his past, I think you draw some parallels, and I'm not saying that that applies to this situation, but the Service Members Civil Relief Act does provide some guidance when it contemplates a deployed military member's inability to participate in a civil action and allowing the court on its own motion to even stay proceedings for 90 days when it shows that their active duty requirements are interfering with their ability to appear. And I think that's appropriate because he is overseas doing a job for his country, and it has interfered with his ability to meaningfully prepare and be ready to go in this matter. Just for instance, yesterday we tried to speak over Zoom and had probably 30 to 40 minutes of troubleshooting, trying to just get each other to be able to be heard. And we were finally able to connect after that. And then we're able to speak for about an hour or so. But the network there has consistent issues that prohibit Mr. Millington from calling sometimes or receiving calls, not to mention the time differential, which is obviously significant. So we believe at this point in time that Mr. Millington, the trial should be continued until he can return from his employment. And the parties could still appear by Zoom, but in this instance, petitioner is in the room with her counsel and they're able to communicate throughout the trial, even though they're by Zoom, whereas my client is obviously not with me, and it makes it an unfair advantage, I would argue, for him not being in the same room as his attorney. The other reason for the continuance is the motion to withdraw, but I won't get into that right now, but that is one other reason why we're asking for that. Thank you, Your Honor.
Ms. Thompson, this case was filed back in March of 2022.
Yes.
There's been numerous court hearings, discoveries done. I have full trial notebooks that have been delivered by both parties in the case. The court has typically would conduct a trial in the courtroom. The court had made an accommodation to allow Mr. Millington to appear by Zoom. He is here today. I understand there's some limitations regarding his ability to communicate, but I assume you all can communicate by email or perhaps text message or other ways. Is that fair to say?
Well, it's fair that we're able to communicate by email, but I think the court should acknowledge and not to force that opinion, but the difference between being able to sit across from someone and be able to say, what are you wanting to do here? Whereas exchanging an email back and forth or a text back and forth obviously can lead to confusion. And that's one of the reasons why the order for bifurcation hasn't been approved. That's one of the reasons, obviously, why we're asking for this continuance, because it's just been extremely difficult to communicate. And I don't want to get into attorney-client privileged issues, but that has hampered my ability and Mr. Millington's ability to prepare for this hearing. And that is why he's requesting the continuance.
All right. Thank you, Ms. Thompson. Ms. Campbell, your response?
Thank you, Your Honor. My client does not agree to a continuance. Obviously, she believes this is just another attempt for Mr. Millington to try and control her. He has been an expatriate employee for the majority of the parties' relationship. He's not in the military, so we would argue that the Soldiers and Sailors Civil Relief Act does not apply in this case. He is a private contractor. We have been in close proximity of what we thought was an agreement or a compromise on multiple times, which then he either gets a new attorney, he falls out of agreement with it. My client has had to pay me to update 3 of his attorneys on what the status of an agreement was or what, we had negotiated back and forth. This was filed in March 2022. He was here. We served him. He signed a certificate of service here and was in the United States on our ground until July 2022 and did absolutely nothing during that time to resolve this matter. He did not even pay child support until we had to issue an income withholding order that was approved in November. So that's 6 months where he was just refusing to follow an order. This has been set for 12/21/2022, February 22nd, 2023, March 28th, 2023, May 15th, and I will agree that most of these were either for a pretrial or Mr. Millington's request for an appraisal on the property, which still has not been done. It was set for 7/18/2023, and then was set for previous trial on August 29th, which was now continued till today. And I apologize, Your Honor. My voice keeps going in and out. And then waited until the day before trial yet again to request a continuance. I'm sure him and his attorney, I'm not going to get into those issues, but my client has been trying to resolve this. My client is not trying to be obscene. She's not asking, in my opinion, for everything she could ask for. She's living on credit cards to make ends meet. She is supporting 2 of the 3 children because the 3rd child has reached the age of majority. The other one is 18, one is 14. 15, I'm sorry. The 18-year-old will graduate in May. This has been going on for a year and a half of their lives. He's still refusing to pay the 2022 medical expenses for the children. He is refusing to pay anything that is off base, even though the children, it goes on and on, Your Honor. My client believes this is just another attempt to try and control her because right now he has put the car insurance in my client's name and is paying it 10 days late so that there's a $15 fee. He still is not voluntarily paying child support. I think I calculate arrears as of the end of this month as $13,000, $13,028.68. That's how much back child support he owes for his failure to pay. And we believe that child support is not even accurately reflective of his income, Your Honor. I'm not going to say my client's income has not increased in the last year and a half. This has been pending either, but Mr. Millington, if he really wanted to make a good faith effort or do anything to support his children, would be paying child support, and he's not. He complains about an income withholding order. My client does not agree to a continuance, Your Honor. I did submit my request if the court is inclined to grant a continuance. My client has spent $10,000 in attorney fees just preparing and dealing with these hearings, and she would like attorney fees paid because he makes substantially more than her. I think our child support number at the time, and I apologize, Your Honor, let me know if I need to submit the pleadings. I'm not sure with all of the court being down what you have access to, but in the temporary order, he was ordered to pay $1,800 a month in child support and then the mortgage on top of that because of the disparity in income between the parties. My client has been raising the children by herself. He keeps trying to take cars away from her when he randomly wants to come to town. My client does not want this to be continued. And on top of all this, Your Honor, at the last request, the court ordered the matter to be bifurcated. We drafted a journal entry of divorce, and he's refused to sign that, refused to allow his attorney to even sign that. My client would like to refinance the house. I think they're upside down in the house. I think there's extra debt on top of it. They did previously refinance it before the divorce was filed. So at this point, my client just wants to get the house in her name so she can start paying things off. She's attempted to qualify multiple times, and then an agreement falls apart, and he decides he doesn't want to do that. So my client is just at a loss. She has spent a significant amount of money just defending from these ridiculous claims, and she would like the matter to proceed to trial.
All right, I do.
And for anybody who's curious, bifurcated means that they would separate the divorce from the property settlement and do them as two separate things. So she wants to be divorced from him, and then the everything else they'll kind of handle like the divorce in pieces. Basically, bifurcated means just to separate things.
No, we were previously scheduled to try this case back on August the 28th. Again, there was a request from Mr. Millington to continue the trial. I had made an order to allow the trial to be bifurcated.
Other way around.
Looking around to see if that had been filed and find out that it hasn't even been approved yet by the respondent. The court's made an accommodation to allow Mr. Millington to appear and conduct the trial by Zoom, which I don't care to do, but I've got notebooks, I've got a pretrial order. I'm not inclined to grant the continuance of the trial. This case needs to be resolved. So that's my order. We're going to proceed with trial today, one way or the other. Ms. Thompson, if you need a breakout room to visit with Mr. Millington for a few minutes, as a result of my ruling, I'll allow that. Before we proceed further, would you care to have a breakout room so you can visit with him privately?
Yes, Your Honor, because I think there are remaining issues in regards to my representation of him, and the motion to withdraw is still before the court. So I don't know if the court wants to take that up first or have me, but I will need to visit with him, yes.
Well, I was going to allow you to visit with him before I take up the motion to withdraw, if you wish.
Okay. Yes, please, if you don't mind, Your Honor.
All right, Mr. Millington, we're going to allow you to visit in a breakout room, which is a private conversation with your attorney. Do you know how to do a breakout room? You'll receive a prompt. I believe it's usually purple that says join. If you click on that, you'll be in a private breakout room. And then you can, when you're ready to come back in, don't leave the meeting itself, just leave the breakout room. And I'll go off record and off camera until I see you all return. We're in recess. All right, we'll go back on the record, let the record reflect the same appearances as before. Ms. Thompson, any announcement after returning from the breakout room?
Not, well, sort of, Your Honor. Mr. Millington did advise that he does want me to remain on as his attorney, but I would like the court to still rule on the motion to withdraw for the reasons that were stated in it. Pursuant to KRPC 1.163 and 4. And then I cannot really get into the remaining issues due to the confidentiality of the matter, but that is where we are. So I can go ahead and make that argument on the motion just briefly if the court is inclined.
All right, I'll allow you to do that, Ms. Thompson.
I believe that Mr. Millington should not be punished adversely, for the change in attorneys. I am his third attorney at this law firm, and that is not due to his choices. That is due to attorneys coming and going. So I just want to make sure that that's clear to the court. But there has been a significant amount of time where there was little communication on my part. I take full responsibility for that, and I don't believe that that is fair to Mr. Millington, and that is one reason for the motion to withdraw. The other reasons are due to the rule that I cited, 1.163 and 4. And so I would ask the court that it grant that motion to withdraw, but I also think that obviously if the court is going to do that, given Mr. Millington's position that he wishes me to stay on the case, that there definitely should be some kind of time for Mr. Millington to obtain a new attorney. And I think there may be some agreements that we can reach in terms of refinancing the home and getting the bifurcation done. But for right now, I'll stand on what I've put in the motion and the arguments that have been made for the court.
Right, Ms. Campbell, do you wish to be heard on the motion for withdrawal?
I don't know that I have any response, Your Honor. I will agree that yes, 3 of the attorneys he has had, I believe, are at one firm. I know he's had 4 total, so I know he has changed firms at some point. I again believe this to be a delay tactic. My client believes this to be a delay tactic. I understand, and I expressed this to Ms. Thompson. I am not trying to put her in an awkward spot, and I'm pulling up the rules of professional conduct as I speak to see what she's referring to. So I've not, but I understand she's in a uncomfortable position, and I'm not trying to abuse her ethical responsibilities or do anything other than I understand her position, Your Honor, but my client would like to get this resolved. And again, we believe this just to be another delay tactic. And if he fires Ms. Thompson and then hires another attorney, what's going to happen then? So that's kind of where we're at, Your Honor.
Thank you, Ms. Campbell. Ms. Thompson, you did say something that I wanted to follow up on. You mentioned something to the effect of agreeing to the bifurcation into refinancing. I know in one of the email communications from Ms. Campbell, she indicated if the matter were to be continued, she would like to see these particular things happen. Is that what you were referring to?
Yes, that is what I was referring to. And just to clarify that a little bit, pretrial order that was submitted, our position is that the home should be awarded to the petitioner and it should be refinanced. And if that's not able to be done, that it be sold. So that's why I think that that is not something that's necessarily can't be done if we want to do that today and then go ahead and do a continuance. But I would need Mr. Millington to affirm that for me.
Okay. Well, I want to read through the rules you've referred to regarding your motion for withdrawal. While I'm doing that, I don't know if perhaps Ms. Thompson, you and Ms. Campbell would want to go into a breakout room to confer upon those particular conditions you were referring to. Is that something you all would be willing to do at this point while I'm reviewing those rules?
I'm happy to talk to Ms. Thompson, Your Honor.
Yes, Your Honor.
Okay. Well, let's go into let the 2 of you go into a breakout room. We'll take another brief recess and then we'll return and see where we're at. We're in recess.
Angela, I believe Deborah's gonna ask to go into a room with Mr. Belgrave or Millington. I'm combining his names. I apologize.
Okay.
Ms. Cool, would it be possible to have a breakout room with Ms. Campbell again?
Sure, I'll get you right in there.
Thank you.
Thanks, Angela.
You're welcome. You need a breakout room?
Angela, Your Honor, I think we have a brief agreement to announce, assuming we can do that. I'm still objecting to withdraw and continuance, though.
All right, we are ready to go back on the record.
Yes, Your Honor.
All right, we will go back on the record in the Millington case. Same parties appearing as before. The parties have been conducting several breakout rooms. Is there an announcement to be made at this time?
I believe we have a tentative agreement when I don't care if Deb or I do it. The divorce bifurcation would be granted, and let me know if I'm misstating any of this. My client would be given 60 days from the date of the bifurcation journal entry file stamp to refinance the mortgage. And if she is unable to, then it would just go back to the remaining issues for trial. In that same time period, Mr. Millington would pay his child support arrearage, which is approximately $13,028.68, but would reserve the issue for trial, which I believe we've already done for back child support, because we believe it should have been higher and they believe it should have been lower. So that is
Ms. Campbell.
Yes.
Since I don't have a court reporter here, but we are taking a record. Could you slow
I
down
will.
a little bit, please?
I apologize, Your Honor.
I'm trying to take notes and I'm having a hard time writing it down.
So I'll go back to the house. So we would bifurcate and grant the divorce. My client would be, the petitioner would be granted 60 days to refinance the mortgage.
She's happy something's finally getting done, because this is the first time that Mr. Millington has been willing to move forward on these issues. He's refused to sign petitions. He's refused to sign the bifurcation. He has gone through, either by their choice to withdraw or him firing them, 3 attorneys so far, and now this 4th one wants to withdraw. He's I think his attorney probably told him, look, you need to piss or get off the pot, because this is just too much. And I mean, he's being deliberately spiteful, putting the car insurance in her name and then deliberately paying it late when it's court ordered that it's his responsibility to pay that. He deliberately, pays it late so that there's a fee on it. So he's being spiteful and petty.
And that would be, that 60 days would start as of the date of the file stamp on the bifurcation or the divorce journal entry, just because she's going to need that to refinance. And in the meantime, he would continue to pay the mortgage until the next trial setting. We calculate the child support arrearages as of November 30th to be $13,028.68. And before the next trial setting, or in the same time period that Miss Millington would have to refinance the mortgage, he would pay that arrearage. We would reserve Mr. Millington's request because he believes he is overpaying child support and we believe he is underpaying child support, back to the date of filing, and those issues would continue to be set for trial. The phone accounts, Mr. Millington currently has all of the kids' phones and my client's phone on his account. He would release all of those numbers. My client would be able to start an account and take all of the children's phone numbers with her to do so. And then the court would reserve jurisdiction to determine who should have been paying the children's cell phones at the trial date or whatever we wanted to do regarding that, since he has been paying them and my client would likely have to take them over in order to start a account in her name. And then Mr. Millington, I believe, is going to be in Kansas February 15th if perchance the court were available to do something that day.
And Your Honor, I would just add to that, I'm tabling my motion to withdraw at this time.
Okay. All right, so Ms. Thompson, your client's agreeing to everything that Ms. Campbell just set forth on the record?
Yes, Your Honor.
All right, and I expect that this order that's going to be circulated is going to be signed without delay?
Yes, Your Honor.
I would like permission, Your Honor, to submit it via Rule 170 for no reason whatsoever, Your Honor.
I think that would be appropriate. Now, this February 15th time when Ms. Thompson, your client's going to be back in town, what, is he just going to be back for one day? Surely he'll be back longer than that.
Mr. Millington can correct me if I'm wrong, but I believe he has a week available to him, but of course he has to take into account travel days. So the 15th is the day that works the best for the trial.
Angela?
That's our Greenwood docket day.
Okay, that's not a day that's going to work on my calendar.
And then the following week is jury trial week.
I'm not sure what Mr. Millington's availability is. It looks like I am free most of that week. It looks like I'm supposed to be in Topeka Thursday night, but other than that, I am free that week. I'm not sure what his availability is, though.
Well, the issue is that week of the February 15th is my criminal docket week, and I don't have availability to do a full day trial. Then the next week, of course, is my jury trial week. Of course, sometimes trials don't get announced, but I won't know that until those pre-trial days. So that's the issue that I've got with that time frame.
Just so I understand correctly, the entire week of essentially February 12th, the court's not available. Is that?
Well, I'm looking here again. I've got criminal dockets each day. So I am not available any of those days.
Okay. Well, I guess if the court would just provide some availability for 60 days from now, I could speak with my client about it. I think that's what we can do at this point.
Angela, can you?
I'm sorry, Judge. We are available the week before on the 6th or the 7th February.
Looks like I'm in a fun trial on the 7th in Sumner County. But it looks like I'm supposed to be in Butler County the afternoon of this. And I'll be clear, I cannot imagine my case in chief taking more than an hour. So I would be happy to set this for the morning of February 6th if we could do that. And obviously I'll still be there in the afternoon. It's just a pre-trial, I think, with Judge Hart.
That would work for me. I just wouldn't know about Mr. Millington.
Fair.
If he can confirm one way or the other, if he'd be okay with that date. Or if he needs to talk with me.
No, I just need to send that up to corporate, and like I said, this has to be done. So the worst case scenario is I don't get back in time when they fill my position. So the 6th is good. I'll relay that to them.
So February the 6th for an in-person?
Yes.
Yes, Your Honor.
All right. And Angela, do we have the full day we can set aside?
I do, Judge.
Yeah, we'll go ahead and set aside the full day. If we don't use it, that's fine, but I want to have it available because we all know those always go longer than we anticipate. Okay, so Ms. Campbell, you're going to be drafting the orders from today's hearing.
Yes, sure.
I guess for purposes of the record, the motion for continuance is being granted with the stipulations that have been set forth here on the record that both counsel have agreed to, as well as their clients. That order will be submitted by Rule 170. Then the trial will commence February the 6th at 9 o'clock in the morning at the Butler County Judicial Center, Courtroom C. Do we anticipate any additional exhibits or?
To be candid,
but I'm not sure.
I would probably do an updated KPC like I did this time, as well as an updated worksheet. With permission, I would like to do a business record subpoena to the respondent's employer to get his pay information. And I would like to request his updated USAA statements, whether that's through a business record or through discovery. But due to the fact that our last discovery request only contained statements through November of 2022, and I did not anticipate needing them, I would request that we be allowed to do that, Your Honor.
And I would ask for the same in reverse, Your Honor.
All right, I'll grant the request and it'll pertain to both parties. Now, one thing that does concern me is the motion for withdrawal that you're asking be tabled. I don't want to be put in a situation where we're on the week of trial and this comes up again. Ms. Thompson, so.
Yes, Your Honor. I guess, I mean, if the court wants to put in a deadline to file that ahead of time, I would be fine with that. I believe that we've resolved what we needed to resolve. So I don't anticipate needing to file the motion withdrawal or to bring it back up, but I'm happy to have a deadline as well if the court wants to have one.
Yeah, we should probably do that. I'm gonna put that deadline by January the 5th.
Okay.
And I don't know if it's relevant for today or if you do happen to resubmit this, but it was under Rule 1.16 and you just listed subsections 3 and 4, but there's a subsection A, 3 and 4, and a B, 3 and 4.
Yes, it should have had B in there, Your Honor.
Okay.
I apologize.
All right.
That does make a big difference.
All right, Ms. Campbell, anything else we need to take up while we're here this morning?
No, Your Honor.
And Ms. Thompson?
No, Your Honor.
All right, Mr. Millington, I just want to make sure you've been able to hear everything okay from your location?
Yes.
Okay. All right. Well, if there's nothing further, then we'll be in recess. Ms. Campbell, if you can just get that paperwork started. Obviously, it's a little more difficult to do under our current situation, but you were around back in the good old days, so.
What we're finding over here is that apparently all of the clerks who knew how to do paper filings retired during COVID. So it's been lots of fun, but we will figure it out, Your Honor. Would you, if we get signatures, do you want us to just fax file it or email it to Angela?
Angela?
Email.
Email? Okay,
Yeah.
we'll do. I know, it's a silly question, but you'd be amazed what different judges want to do. So we will email it. Thank you, Your Honor.
All right. Thank you, everyone. Have a good day.
Thank you.
All righty. Okay, so I didn't want to interrupt the case, sorry. So right now there's kind of 3 on the, well, they're not exactly all entirely on the books yet. They're to be on the books. The only one that's actually scheduled is for my foot, and that one is coming up February 21st. They have to go in and remove part of the bone of my foot on each of my feet. So yeah, they're going to start with my left foot because that's the worst one. And then they decided today that they're going to do it's not actually a surgery. It's done by the surgery center though, but they've got to go in and do a nerve block with the administration of steroid injection as well. So that's done at the surgery center. And so that one's not scheduled yet. It was just put the order in for it today. So that one is, I have to wait for the call from the surgery center to tell me when that one's going to happen. And then as far as my, other foot goes, they just have to wait and see how my left foot heals to determine when they're going to do the right one. So that's and I'm still not even healed from the last surgery that I had. So, but I should be by the time we do the next one. Because it was 6 to 8 weeks of healing for the last surgery, and we're just passing 2. So, yeah, fun times. Fun times. No, don't be sorry. That's my rule. Don't be sorry. I've got a good life, you know. I've got some amazing friends, and you are my support system. And that was my cat. What the heck? That sounded like a robot. Y'all hear that? Wow. Come here. You. Oh, ow. Hey, you're getting fat and heavy. Yes. I know you're so mad at me because I won't let you outside because it's negative degrees. Okay, go up there. Big ol' meanie. Yeah, my cat barked. At first I thought my heater had like a short or something. No, my cat had a short. But no, you guys I am so much happier now than I was, golly, forever ago, ever. When nothing can be done about the pain other than the distraction and having something to laugh about and people to laugh with, that is better than Percocet or Dilaudid or any other drug that they could prescribe. Having people who genuinely love you and care about you, that's what truly matters, and that's what truly makes a difference. So I've got a great life. Getting hit by the SUV sucked, and every day since has been painful and traumatic and rough. But I'm doing well. All things considered. Could have been worse. And I'm very grateful just to even be alive. And now my cat is kicking my shit off of my dresser. No. So she, as far as I know, she wasn't even charged with anything other than like she might have gotten like an inattentive driver citation or something, just a citation. But what happened was I was waiting to turn on the main drag in town. There's a road called Superior, and it's actually a highway road. It's 4 lanes of traffic with a median in between, right? And I was waiting to turn into traffic and just go on my happy, merry right turn way. And so I was watching down the left side and like waiting for an opening. And then so behind this SUV, there was a large opening. And oh, goody, I can get through. And so my line of sight was trailing with the SUV. And all of a sudden, like just as it got to the, where the median opened up for like where the division of the road is basically, just as it got to that point, all of a sudden, like, or right before that, you hear, or the hearing and seeing like happened simultaneously basically. But I saw the vehicle gunning it across the road, but she gunned it right in front of the SUV. She was turning left to go onto the road that I was on, and so she gunned it in front of the SUV, and the SUV struck her car, and then the impact like turned it my way, and it like turned my direction and barreled full force, like 45-degree angle into my driver's door. Yeah. And yeah, it sucked. I watched it. I watched the whole thing because, like I said, I was trailing the SUV because it had my opening, and then so like all of a sudden out of my peripheral, I just see this idiot coming, and like the only thing that I had time enough to do was I threw my arm up like this, like I'm gonna stop an SUV from doing anything. But I'm glad I did that. My arm, I don't know if you'll be able to see because, like I said, lighting sucks in here. But my arm has a crap ton of road rash. I don't even know how to show you the scars. Let me see if I can. But I'm really glad I did that because if I hadn't, then the road rash would have been all on my face. I don't know. Can you guys see that? No, not really. Crappy camera, terrible lighting. I can't show you. But yeah, my whole arm was chewed up pretty bad. But all through here, I've got pictures of it. Maybe I'll put them up. I'll put them up in the Discord with a disclaimer. And then the airbag deployment, like they initially thought my spleen ruptured because from just under my breast to my stomach, like there was this huge area that instantaneously was purple, dark, deep purple. So they thought my spleen ruptured, but no, it wasn't internal bleeding. They did all the x-rays and stuff, and all my organs were fine. It was a chemical burn. So over the course of the next several days, my skin went from that deep purple to gray, and I looked like I was on a casting call for The Walking Dead. My skin literally just peeled off of me. And then I was left with, if y'all can think of, like, if you have a blister that pops and the skin peels off of it, that raw, open, like, it hurts when cold air hits it, skin that's exposed, that my entire side was that. It was awful. And then I got prescribed the wrong bandages for the wound. the ones that I had gotten from my insurance, like stuck to the skin, and I needed like some specialty ones that had like this foamy, spongy, wet pad in between the layers, and yeah. So, yeah. Sorry, I wasn't even looking at chat. I was on. Yeah, I'm really glad that I did that. Yeah, I can't see it on this camera. Like the camera quality, like what I see in my little laptop picture is probably a lesser quality version than what you guys see out there in YouTube land. And that's actually how I found Law Talk with Mike right after my accident. And the chat, the community, is what got me through my accident. It wasn't even necessarily Mike. Yeah, Mike's great and all, but I was so in love with the community, and that's why I stayed with his channel, and that's why I started editing videos for him. I wasn't editing videos because he's got such a nice chest or anything like that. It was the community. It was the people, and I fell in love with the community, and I wanted to give back. They got me through some really hard times, and then Mike encouraged me kind of to do this. Well, he basically just asked if I was going to, and I said not that I really didn't want to, and he's like, well, you should. And that was it. Then I did. So well, I hope lots more people find me and stick around. But all right, guys, I am going to go to sleepy, sleepy baby. Sleepy, sleepy Betty bye. With my cat, who's now comfortably resting on the dresser that he's knocked everything off of. I love him. I love him so much. I love you guys. I really do. Genuinely, truly, absolutely love you guys. Every one of you. My replay crew included. Y'all don't think I forget about you just because I'm interacting with the chat. I love my replay crew people. Y'all, this is when I know that I'm done. I can't even talk. I love you. All y'all. Thank you. Everyone have a great night. Sleep sweet. And I will see you. Yes. Yes. My replay crew. So you guys are like my co-hosts. I couldn't do the show without you. So you guys are like my co-hosts. And the replay crew, they're my rock star audience. And Philip is the in-house comedian. Oh, all right, guys. Be safe, be well, and much love.